We don't know. We hadn't heard from her. Oh, we think she is. As far as we know.
That was just that my computer was unmuted. She could. Oh, okay.
And here she is.
All right. No, the police said so to go. Yes, this is all for you.
This has got like, it's gonna go on for months.
You're good. Good morning.
I'm sorry.
Right. Attorney Hattersall, can you give me a thumbs up if you can hear us? Oh, no, it's today's project. I know. Sorry.
Hangover effect.
All right.
All right, we'll call the meeting to order. Good morning. My name is Ed David. On behalf of my fellow commissioners, I welcome you to this meeting, the Maine Human Rights Commission. Before we proceed with business of today, I'm asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. Give me 3 seconds. I will ensure that mine is silenced now. We have additional agendas, including the consent agenda available online and in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted time. The commission will vote on those cases and they will not be considered further today. The remaining cases on the agenda are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in the order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium or recognized online to provide the most relevant arguments to the case. The time is limited to 10 minutes for those arguments. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only 1, relevant factual errors, 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself as you are recognized to present argument.
Put on my teeth.
We'll start with the business meeting, and I believe there's a amendment to the agenda. Aren't we tabling something?
I don't think we need a vote
You
for
don't need
that.
to do that.
So I think I need just a motion to adopt the agenda and consent agenda.
Okay, I will move to adopt the agenda and the consent agenda.
Second.
Moved and seconded. Any discussion? Right, seeing none, the commission's remote participation policy asks that the commissioners indicate their votes both verbally and visually. If you vote yes, you are in agreement with the motion to adopt the agenda. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders? Yes. And I did not put this on the agenda, but we didn't do the January meeting,
Right.
the last meeting, January minutes.
Right.
The last meeting, because I forgot to send them to you. So I sent them to you for this time, so we'll do a motion for the January minutes. And a motion for the February minutes. You can do them together or separately.
I reviewed them both, and I personally found no additions. Are there any amendments or comments on the minutes? Hearing none, I'll move to accept both January and February.
Moved and seconded, any discussion?
Don't wait any.
Seeing none, if you are in agreement, you vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes.
Okay, business.
Yes. So we have no change to personnel. For compliance, you have a memo from Jane. We have 4 active cases in conciliation and 1 unsuccessful conciliation. I don't have any agreements, but I do have a memo from Jane to dismiss H230404AB, Earl B. Cassett Maloney. So I just need a motion to approve that dismissal.
So moved.
Second.
Moved and seconded. Any discussion? None. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
For investigations, we had 49 new complaints filed last month, for a total of 67 respondents. 15 cases were administratively dismissed. I sent out 5 right to sue letters. We had 9 predetermination settlements, 2 private agreements, 2 through the commission's mediation program, and 5 settled while they were in investigation for a total of $285,000 to agreements. I would ask we take litigation and executive session. And for new business, not much. Our budget initiatives got voted out of the Judiciary Committee as ought to pass. So now they are with appropriations, and I assume at some point I will hear whether or not they got voted in. Appropriations work sessions are sort of a black box, and even the people I know on appropriations don't know if they voted these in or not yet. So at some point I will find out. If I had the time to just be listening to appropriations work sessions all the time, I would, but I have other things that I need to do that too. Otherwise, not much. We are moving steadily along. The next few commission meetings will be about the same number of cases probably as we work through the backlog, but I will continue to feed you. There are snacks, please have snacks. There will be lunch. I have the Whippers menu for later. Stay hydrated, have some coffee.
Any financial updates?
Not so far.
Funding or?
We're still waiting on, well, no, actually I did. I can't remember if I talked about this in the last meeting because I think I might have signed the contract that day. We did get a contract from the EEOC. It is for, all they have guaranteed us is 20% of our funding. It has always been my understanding that both of our federal contracts are subject to appropriations at the federal level. There are clauses that are just incorporated into the EEOC contract that say that. So I have never seen in the line item where they say how much they're going to pay us, language about we only guarantee, I think it's $49,000 for us. We're only guaranteeing you this much money. We don't have the funds yet for the rest of it. We will like keep you updated. And then there's another line that just says $TBD. So I am not counting on that. I did, I think, present that when I presented my testimony to appropriations, saying, look, like, as an example of why I am uncertain, here is my contract with the EEOC. In prior years, even though those contracts were also subject to appropriations, they have at least given us we anticipate paying you the full amount, and they say what the full amount is. So at this point, $49,000 isn't nothing. I will take it, but I would like.
What does that compare to what we?
Our contract, our contract with the EEOC is usually somewhere in the range of $200,000 to $250,000.
Right.
And so we usually, there's some back and forth about how many cases are you going to close. We've looked at your prior years. Here's what we think. What do you think? We go back and forth a little bit. I sent them an estimate of the cases I thought we could close, and I did not hear anything back confirming that we would get a contract for that number of cases. $49,000 is about 20% of that number. So I'm just sort of assuming that but trying also, of what happens when you assume things. So
Yeah, I don't know. When do we blow the panic button?
not.
I mean, we're going to overextend ourselves.
No, we are fine in our federal accounts in the EEOC for I think a little over a year,
Oh,
in the HUD account for a few years. That we are fine because we have 2 investigator positions that are currently vacant, and I'm not hiring for those.
That's the answer to my question.
Which is what I have gone to appropriations and said, like, this team has worked incredibly hard to get our time like our processing time down. I think you've seen the case numbers when I give you the case inventories every quarter.
Mhm.
That the average case age is less than a year. Average time to get to me or my hold for review for mediation is way shorter than it used to be. It's 4 to 5 months where it used to be 6 to 8. Cases are getting to investigators much quicker. This is good because people are always frustrated with how long these cases take. But we are at capacity right now. And if I can't hire those investigators, at least one, those numbers are gonna start to go back up because we just, and it takes a year to get an investigator fully up to speed most of the time. Yeah.
Are you the only one who administratively dismisses?
Yes, but anything that gets administratively dismissed is reviewed by Barbara or Colin, and then also it goes to an investigator to review as well. So
So it's not like,
it's not just me being like, meh.
yeah, okay.
No. There are many levels of review before it goes out.
That's all. Today's a bad day. You're all out. I know.
No. Yeah, sometimes I wish I had that power. but I don't have.
Yeah.
No, I just no to this.
Oh.
We have some, I don't know if I want to call it redundancies, but we have many levels of review before a case is moved out that way. And honestly, we have a couple levels of review for when a case goes to mediation and when a case gets dismissed. And the only thing that we basically don't review is the people who send in requests for right to sue letters after 180 days because we don't have any discretion there. If they ask for it after 180 days, we have to do it. So.
And if you give them a right to sue letter, there's no investigation.
No.
We don't hear from it again.
No, although sometimes a couple of years later, I see them on the SJC like list of decisions.
Yeah.
So I know they're going out there.
Not telling us.
It's fine. We have enough to do without worrying about other people filing lawsuits.
And the case activity, the incoming cases seem about the same,
Yeah, that's
49.
I don't actually have an average off the top of my head, but that doesn't surprise me.
Mhm.
So, yeah. Any questions? But let's take a couple of minutes.
Yes, we will, not long, about.
A minute and a half, just enough time for somebody to get coffee if they need it.
Some of our late arrivals.
Oh, please. I have it. Maybe.
Just keep it moving.
Like just accepting
I
a
think
death.
doing that with the shady
Like-
colors, trying to inspire spring colors, it's not working.
Nice effort.
It is a nice effort, isn't it?
When there is, I think you may have seen, there's a packet. Yeah, it's here. I told people brought a book. And it's gonna be here for almost years. No, just that's what we had talked about. Yeah, I have asked them to be here for meetings, this meeting, April and May, and we can sort of reevaluate after that.
Yeah, you scared me.
Are they just sitting out here, Kip?
I think so, yeah.
Yeah, this thing, yeah, so. Okay, we'll call the meeting to order and begin the agenda for hearing cases. This case on the public's agenda is tabled. We'll hear ED 240023, Travis Kerrigan versus St. Joseph's College. It's a disability accommodation case. The recommendation from the investigators for a single finding of no reasonable grounds. Therefore, we will call on complainant. They wish to make a presentation.
Before we get started, I would just like to remind everybody here on Zoom that the MHRA's confidentiality provisions require that names of third parties remain confidential. So please do not use the names of people or entities who are not named parties, either the complainant or the respondent to the case. You may use the pseudonyms from the report or the person's title or relationship, i.e. supervisor, landlord, company, etc. But please do not use the names of persons who are not parties to the case. Mr. Kerrigan, you have 10 minutes. Do you want to save any of that time to respond to Attorney Strader after he makes his presentation?
Yes, please.
How much time would you like to save?
5.
Jane, can you turn that?
I overcorrected.
Just 1 minute. We're just making sure that we can hear you.
Okay.
Okay. Whenever you're ready, go ahead.
Okay. So pretty much my thing is that with the Maine Human Rights Commission, we requested from St. Joseph's College email documentation from a professor, which unfortunately the syllabus didn't provide, and unfortunately they withdrew me without me signing anything before I was able to copy, print, or do anything with that information. They only sent emails from the pathophysiology class, not the nursing class that I had mentioned, that had the emails from the professor saying like, hey, I talked to the disability coordinator at St. Joseph's and they said something completely different than what she told me. So I feel like the disability coordinator was playing both sides. She was playing me, she was playing the faculty, and telling us two different things. So the communication with St. Joe's was not standard. I did not get the accommodations that I requested. They tried to claim it after the fact, after they had approved the Taught to Test software, that it wasn't an accommodation because it was available to all students. Unfortunately, that software didn't work. The disability coordinator tried to set something up, and the ABSN program essentially denied it because their exams were taken over the weekend and disability services was not offered over the weekend. So for that fact, I found that the case report by the reporter was kind of flawed, in my opinion, because of the fact of they really never made a full plan. Like I was told by the faculty, I couldn't make the accommodations that the disability department agreed to, and then disabilities tell me that they had accommodations in place. So where am I supposed to stand? I mean, in my case, like I'm being told two different things from the faculty and disability services. I'm caught up in the middle. I don't know. I'm a student. Like we really aren't taught how to navigate this type of situation where you're supposed to go to disability services and they're supposed to help us out. But I feel like the program kept pushing back every single time that the disability coordinator tried to implement something, and all three parties weren't connected. So I feel like that was a failure of St. Joe's. They didn't communicate with all three parties properly, and I was dragged in the middle, being told two different things between the ABSN saying, hey, we're not doing what you were told by disability services. They told us something different, and then disability service was telling me something. So that's my case.
Any questions and I'm apologize. How am I pronouncing your last name correctly?
The first end silent, but Kerrigan.
Kerrigan. Okay. Questions for Mr. Kerrigan? Okay. Commissioner Douglas.
Yes, Mr. Kerrigan, good morning.
Good morning.
Yeah, I've read the report and I've read your appeal, and I guess it's just not clear to me exactly what it is you feel that these folks didn't do that gives rise to this MHRC action. Can you just give us, can you just give us like the condensed I'm looking for like a list. What is it you claim that they didn't do that they were supposed to do?
I didn't receive the accommodations that I was supposed to. There was issues with the software for timing, so I took some exams and I got cut off without the time extension. I was supposed to be able to use a taught to text software so that I could listen to the questions. That was never implemented. Their software wasn't working, so disabilities offered to have either a work study or the woman in charge of disability services meet with me one-on-one, and she suggested Monday morning. The program said that that was not acceptable because it went outside of the exam window, which was over the weekends, and disability services is not open over the weekends. So it was just multiple things that I had asked for and that the college agreed to, and then they never provided that. And then when I mentioned that I was filing a complaint with the Maine Human Rights Complaint, they withdrew me from the school without me signing anything. So I never signed anything saying that I withdrew from the program. I never signed anything saying that I withdrew from St. Joe's. I was left in limbo for almost a year until I heard back from the commission whether I still owed tuition or not, whether I had a transcript there. I never got that clarification until the Maine Human Rights had a meeting between me and the university's lawyer. So I had a lot of
Okay.
questions and I was not getting answers. So I feel like that was a complete cover up on their end and they retaliated as soon as I said, "Hey, I'm filing a complaint with the commission. I feel like this is like a huge issue." And then I got pulled out of their system. I couldn't, like I said, I couldn't print off the emails. I didn't have that evidence. And then they agreed to provide that evidence and never did.
Okay. So leaving aside all of the retaliation type facts that you just spoke about, what I'm hearing is the exam window was problematic, whether the test can be taken on Monday over the weekend, and the talk to text program is problematic.
The TOTS test program never worked. They tried to make an accommodation. It was pretty much accommodations was trying to make an agreement with me for accommodations, and then the department kept on saying, "No, we're not doing that," or "No, we were told something different from disability services." So all three parties, myself, disability services, and the program were never clued into the same page, and I kept on hearing two very opposite things from the department and disability services.
Okay.
So
All
I
right,
never
thank
got
you.
the accommodations that I had requested.
Yeah. Okay, thank you. Thank you.
Commissioner Sanders?
Just one second, someone's telling me that the audio is going in and out again, I'm just gonna double check the. That's the echo canceling speakerphone, right?
I think so.
Okay. We'll keep going, I'll just move that a little bit closer. Thank you.
Good morning, Mr. Kerrigan.
Morning.
Nice to see you this morning. Thank you for coming. I'm curious about something you just said, which I think is inconsistent with the investigator's report. So I want to give you an opportunity to address it. I think I heard you say that it was the college that withdrew you and that was a surprise to you. And that otherwise you may not have been expecting it and didn't want that outcome. I read in the investigator's report, though, that the reason you were withdrawn was because you communicated your desire to be withdrawn. And that was the moment at which the withdrawal procedure began and was ultimately affected. So tell me about that seeming discrepancy. Did I get that right, or am I missing facts?
I did mention to the disability coordinator that I did not want to continue, but I had not been formally spoken to. I said I still wanted to know like my options and stuff. Like I didn't give her permission to withdraw me. I just said I was thinking about withdrawing, like stuff isn't really working out, like I'm not getting the accommodations, I'm having the department fight with me every 2 seconds. But it didn't give me the decisions of, is this gonna affect me financially? I never got that type of counseling. I just all of a sudden tried to lodge into my class one day and couldn't get in, and then I couldn't get into anything for St. Joe's, and I found out that I had been withdrawn.
And did you immediately follow up with St. Joe's to rectify the situation if in fact it was your intent to remain enrolled?
My what's the technical term? I guess it was my advisor contacted me, and I said she didn't even know that I had been withdrawn.
Okay, but my question was, did you follow up immediately?
I tried to, and I wasn't getting any answers, and I assumed that was because of the complaint that I filed.
When you say you tried to, could you describe the steps that you took to try to follow up with St. Joe's?
I made a phone call to the dean's
clarify-
office
Hang on
and
a second, Mr. Harrigan.
okay.
To clarify that, in fact, you were withdrawn, you couldn't get into your accounts, and that it was not your intention to withdraw. So I'm curious if you can describe for me all of the steps that you took to clarify what your intentions were at that point.
I called up the dean's office and asked what had happened. They said that I had been withdrawn from my classes and stuff, and I just assumed it was retaliation and I didn't want to deal with that school anymore. So I kind of gave it up from there and just said, you know what, I'm going to handle this through the Maine Human Rights Commission.
Okay, but I think what I heard you say is that you did not clarify your intention to remain enrolled. Is that right?
At that point, I just thought that it was another step of retaliation, and I had had enough of that scroll between going over a month of trying to get accommodations and not getting them, and then just being forcefully withdrawn. I'm like, why would I want to deal with a company or an education place like that? So at that point, I was like, whatever. I'm like, I'm withdrawn. I don't have to deal with them. I may owe some money. I don't know. But I will let the Maine Human Rights deal with this because I thought that I had a strong case for retaliation and discrimination. Um, I just didn't want to deal with it anymore, but I did have some lingering questions which nobody answered. I was told that I did a call back and I never did.
Thank you very much. I appreciate you engaging with my questions.
Thank you.
Thank you.
Any other questions for Commissioner David?
Good morning, Mr. Kerrigan. You said several times, just in the last few minutes that you want the Maine Human Rights Commission to deal with what you believe is retaliation for your complaints, yet the complaint is failure to give you a reasonable accommodation. What is your complaint against St. Joseph's?
That was the initial complaint. When I filed the complaint, while I was still enrolled in the school, is I filed the complaint for discrimination. Later, I was retaliated against, which I don't know if I was supposed to file something separate or what, but.
Right, and Commissioner Douglas was asking you, what is the accommodation that you say they failed to deal or try to make for you?
I never got extended time on a couple exams because they apparently had system issues and stuff like that. I never received that taught to test software, which now they're claiming every student had it, so it's not an accommodation, yet the software didn't work. And the disability officer tried to set up a one-on-one appointment so that I could have a student, a work study student or herself, read the exam to me as an accommodation because the software wasn't working. So it seems like they are backtrailing quite a bit
Did they
on
do
what
that?
they told me.
Did you avail yourself of that offer to have them read an
I
exam?
wanted
you?
to do it. She offered for Monday morning for me to do it, and the department said no, it had to be on Friday. So I was receiving very different messages, and that was the continuing theme at St. Joe's. Is I kept on receiving a message from Disability Services and then something completely opposite from the ABSN department. And unfortunately, all three parties never met together to get on the same track. And I
What
think
are the
that's because it was a new
conflicting
program
messages?
and wasn't really thought out well and wasn't really structured very well. So I feel like I was kind of the first student with a disability with this new program, and they weren't sure what to do because of the different hours that the program online being compared to the more traditional track. But I can't say for sure, but all I know is I did not receive the services that I had requested.
Cool.
Any other commissioner questions for Mr. Kerrigan? All right, seeing none, you'll have about 7.5 minutes when we come back to you. Attorney Strader, you have 10 minutes. Do you want to reserve any of your time?
I'll just go, and if I have a couple more minutes, I suppose I'll hold on to it if that's okay.
Sure.
Good morning, commissioners. My name is Dan Strader on behalf of the respondent, St. Joseph's College. I think this is a case, as the investigators report illustrated, and as I think some of those questions just illustrated, where unfortunately the complainant preemptively disengaged with the interactive process rather than accept a reasonable accommodation that would have clearly met his needs. I say that's unfortunate because he had meetings with the accommodations coordinator in which she made plain that she was going to do whatever was necessary, including personally reading him his exams on Monday. That was confirmed both before and after the incident where he was the one incident where he had an issue taking the test. And I think it's important to realize here that no accommodation was ever denied. Nobody ever told Mr. Kerrigan, no, you can't have that. He submitted a list of 6 different accommodations, I believe 5 or 6, the week before school. All of those were granted. The college didn't actually consider, as I think he sort of alluded to, the text-to-speech software to be an accommodation because it just offers that to everybody. But, nevertheless, it was an option for him. Um, I think that's the only accommodation that's really at issue here. And I think it's also important to recognize this all unfolded within a 1-week period. Mr. Kerrigan seems to characterize this as this ongoing struggle where he just couldn't get information and it was this, constant conflict and difficulty. We're talking about an 8-day period to be precise. What he's calling a failure to accommodate was really just a technology issue that happens. Reasonable accommodations are not always immediate. Sometimes there's some trial and error. Sometimes there's some back and forth. Here, the first time there was ever an incident was on September 10th when he tried to take a practice test. He reported he had an issue with the software. That was immediately looked into by IT. I think within a day or two that was fixed. It didn't actually impact him on that occasion because he said he found some alternative software online he was able to use. So it was sort of a no harm, no foul situation. The second time, the only time where he actually had an issue taking a test with this software was on September 10th. He again reported it to the accommodations coordinator. And in the very same email in which he first reported the problem, he said, "I'm frustrated and I want to withdraw from the college." So he sort of already had planted his flag that I'm out on this process. Despite that, the accommodations coordinator, I think, immediately responded. She was very sorry to hear that. She wanted to try to work with him. She scheduled a meeting with him 2 days later. During that meeting, she again offered to provide him with an in-person test reader. The complainant talks a lot about some miscommunication or some conflicting communications between him and the coordinator, who I think he acknowledges sort of said and did all the right things, and his professor, who I think he says has told him he couldn't do these things. We don't have information on that. The professors have not confirmed that. He claims there's emails out there. We have looked for those emails. We don't see emails. The only email that we did see where he discussed this with the professor said she'd look into it and did not say no to him taking the test on Monday. So at the end of the day, the accommodations coordinator testified at the fact-finding conference. She was the decision maker. She had the authority and the ability to override and to make that accommodation. So to the extent he was ever told something different by a professor, that wasn't the final word. And the accommodations coordinator actually said not only could she and would she have done this, and she communicated this to him, she had done this before. This was not, as he suggests, some novel situation that the college had never encountered. It had, and there were other students who had permission to take tests on Mondays with an in-person test reader, and that was something, again, the coordinator offered to him. But at that point, 2 days earlier, he'd withdrawn. He confirmed in that meeting that he did not want to rescind his withdrawal. I don't really know how to respond. There's a sort of a lot of allegations or suggestions about the withdrawal process somehow being improper, or there wasn't something official. There are no forms to sign. There was no financial consequences. His tuition was refunded in full. So, I don't really quite know what that issue is about. This meeting today is the first time I've really heard him, I think, claim retaliation. I'm not sure quite what that is either. But at the end of the day, the college offered him an accommodation, would have clearly met his needs. At that point, he had checked out and he didn't want to pursue that option. And that's unfortunate. I'm quite confident that had he remained, he would have gotten the Monday test, in-person test reading accommodation. But he chose to withdraw, and that's his choice. But that's not disability discrimination, and it's not a failure to accommodate. As the investigator correctly found, the college acted promptly when faced with these technical issues. It offered alternative accommodations that the complainant refused. And we think that the recommended findings of no reasonable grounds should be adopted by the commission.
Commissioner O'Brien.
Good morning. I believe you said at the beginning that there was a specific list of 7 accommodations that he requested. If it's in the record, do you have that list clearly enumerated?
It is in the record. I don't recall offhand. I'm going to pull it up. I believe I can probably pull it up pretty quickly. Yes, it was prepared materials before class, notes, outlines, study guides, PowerPoints, etc., recordings of live lectures, tape recorder, I guess to record lectures, extended time, double time on exams and quizzes. The text-to-speech software, as I said, is not actually listed there just because that was generally available. So maybe I didn't count that all up, but it's 5 or 6 items, and that's Exhibit A to the position statement in the record as well.
Thank you.
Sure.
Commissioner Sanders.
Good morning, Attorney Strader. Thank you for being here. I want to clarify or try to clarify something again, I think I heard you say in your remarks, which was with respect to this seemingly this miscommunication apparently between the disability support services offices and the professor here. I think I heard you say that the professor had not confirmed, right, that she denied the accommodation that the complainant asked for with respect to taking the test at a later date. Does that mean, sort of the turn of phrase is a little bit confusing to me, does that mean then that the professor denied that she ever denied the complainant the accommodation?
So if I can clarify that, there's no evidence in the record as to what the professor did or didn't do because the professor was not called at the fact-finding conference. I can tell you just from us having reached out to them, they did not tell us, yes, we denied that accommodation. So I'm not quite sure what complainant is referring to there. What I was also referring to is the one piece of evidence that is in the record that sort of relates to that. At the fact-finding conference, maybe I'll just back up a second. At the fact-finding conference, Mr. Kerrigan made some of the same sort of claims that he's making now about, implying that we've like deleted or withheld emails or that he, because he didn't have access to see his student account as is typical. That wasn't retaliation. It wasn't sort of hiding evidence. It's just when you cease being a student, your account is deleted. So by the time he filed his complaint, those emails through his account no longer existed. We did search the professors, on their end, you could see what emails they had with his account. And we did not find any emails where anybody denied any accommodation. The one email that we did find and was provided as Exhibit E to our, final evidentiary submission post fact-finding conference was an email with, I won't say the name, I guess, but his professor, who says, and I'm reading it now, "Thanks, Travis. I will get with IT about the issue. I will have to get back to you on the exams on campus, but we'll do that as quickly as possible." That was on September 13th. I'm not aware. I don't have a copy of an email. She may not have gotten back to him. That is certainly possible. It is certainly possible that there were some communications that were unclear. But again, he takes the test on the 17th. He says he has this issue. On the 19th, he's meeting with the accommodations coordinator who's telling him, "I can take care of this." We can, and she was also, I didn't mention this, she was going to make arrangements to either have him retake that test that he had the problem with or have it wiped from the grade so that even that test wasn't going to adversely impact him. But he had made his decision to withdraw at that point.
Okay, thank you. That's very helpful.
Any further commissioner questions for Attorney Strader? All right, seeing none, we'll come back to Mr. Kerrigan. You have 7.5 minutes left. If there's anything else you'd like to add?
The only rebuttal that I want to make on that is I'm sure most people are familiar with colleges and stuff, and if you withdraw from a course or if you withdraw from the campus, there's a paperwork trail. In this case, there wasn't. So I want to make that very clear. And they've never answered that question. They've just said, "Oh, we just took you at your word" and stuff like that. Nobody really had a conversation with me about it, what that would mean for me or anything like that. So that's where I want to end this, and I rest my case.
Any further commissioner questions for, yes, Commissioner Gager?
Did you get that email from the disability coordinator that the attorney just referred to, that they found?
I did receive that in their background information that they submitted. But the email that I've
did
been
you get it
referring
at the
to was from a
time, sir?
different professor for a nursing class and not pathophysiology.
Did you get it at the time that it was sent?
Yes, I did. That one I did receive. I responded to it and stuff like that. I hadn't viewed the email again until they provided it after the commission meeting, where they had me, the disability coordinator, and Attorney Strider there. But that's not the email that I've been referring to. There was a different email by one of the nursing faculty for an actual nursing course, not the pathophysiology course. So to me, this is kind of what we've been seeing with the federal government, with the Epstein files, is they have the files pretty much. I don't have access to them, so I can't really see what emails they are sending, what they're not. So I mean, I've asked the commission and they said it's not their responsibility to kind of look at my email from St. Joe's and kind of look at it themselves as a third party, which is unfortunate because they can pretty much hide the emails all they want to, and I don't have access to it. I don't have the money for an attorney to do a subpoena for them. So unfortunately, it is what it is.
Well, the investigator says in the report that St. Joseph's responded to every request that you made. They responded. You may not have been happy with the response, but they did respond. Is that correct? To try to resolve your complaint?
They provided what they found, and I remember a strict email from a professor saying that I could not take my exam on Monday. It had to be on Friday. So I don't see that email in what they provided.
You don't have it and the professor denies it, right?
I don't know. I haven't talked to any of the professors ever. All I did is email them because this was an online program. So I think one of the professors was from Florida, one was from somewhere else. So my interactions with the faculty was by email. The only in-person person that I talked to for St. Joe's, it was a student tutor and then the disability coordinator. That's the only in-person interaction I ever had with anybody for St. Joe's in regards to those classes.
Thank you.
Any further commissioner questions for Mr. Kerrigan? Seeing none, Attorney Strader, you have 4 minutes and 15 seconds if there's anything else you'd like to add.
I'll just say very briefly, to the extent that any professor, again, we can't locate the emails and there's not a cover up. We can't locate the email he's talking about. To the extent that there's an email in which a professor told him, you can't take your tests on Monday, or to the extent anybody told him that verbally, he had a meeting with the accommodations coordinator responsible for making those decisions and for providing accommodations on the Tuesday following all of this. I don't know what he's claiming the date of the email is, but I'm pretty certain it predates that meeting. And the accommodations coordinator said that she would take care of it and make sure he could have his tests read to him on Monday. So to the extent inaccurate or contradictory information was provided earlier than that, it was superseded by that later conversation. And again, the withdrawal thing, I don't quite know what to make of. There was nothing nefarious about the withdrawal process. He said on Sunday, I want to withdraw. He confirmed in a meeting on Tuesday, I want to withdraw. That's the process. There's no sort of other process that was skipped. And again, this is what he asked for. So I'll stop there.
Commissioner questions for Attorney Strader? Seeing none, we've heard from the parties, and next we'll hear from Investigator Beauchesne, assigned to this case.
Like to cover a couple of things. Number one, the accommodations that were granted are all covered in footnote 4 if you need additional details about what was and wasn't granted. And actually, in this case, all requests were granted, albeit with some glitches at the initial beginning. Again, he reported the problem with the software on September 10th. That was addressed, again, as the respondent had noticed, that was a school-wide issue and was not confined strictly to the complainant. There was a problem with the entire software, which she addressed the following day by using it herself to make sure that it was functional. He's disputed whether or not that was the case, but the coordinator again indicated that she specifically checked into it. And that was fixed within a day, which was certainly a timely correction. With respect to the ability to take the test on Monday, again, as noted, there is nothing in the record that resolves that one way or another. But again, in this case, he was told explicitly by the coordinator that she would make that happen. And if the software didn't work, that they would provide someone to read the test on Monday. So clearly at that point, whether or not he understood the chain of command and who had the ultimate say in this, she assured him repeatedly that she was going to make sure that that happened regardless of the glitches with the software. I guess it's also important to note in this case that this was a brand new accelerated program. So there were some glitches that needed to be worked out. It was the first time it was ever taught. So whether or not this is technology related or accommodations, there were some problems with communicating, I guess, with some of the professors in this case, which of course had nothing to do with the university's ability to grant accommodations or not. And with respect to his intent to withdraw, on September 17th, specifically wrote to the professor, telling them not to bother correcting the exam because he intended to withdraw. So that was pretty clear cut, I'm sure, from the school standpoint, whether or not, and the fact that he met with somebody after that, again, that assured him that the accommodation he needed was going to take place. I think at that point, it just appeared that he had made up his mind that it simply wasn't worth the trouble moving forward. And that was strictly his call, and it's understandable, but in this case was not due to the university or the college's failure to provide an accommodation beyond that they had already granted.
Commissioner, questions for Investigator Beauchesne? Seeing none, thank you, Bob. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding. Sure, David.
I will move that we find that there's no reasonable grounds to believe that the respondent unlawfully discriminated against the complainant and that the matter should be dismissed.
Second.
Been moved and seconded. Any discussion?
St. Joseph's has an individual that's assigned to deal with these problems and worked specifically responding to every request in a reasonable manner and doing the best they could. They're to be commended.
Yeah, I just want to point out that with respect to the accommodations that we've been discussing today, right? Starting with the talk to text program, the investigator's report pretty clearly indicates that issue was remedied quickly. Manager remedied the situation and then verified it with him about a week before he withdrew, the complainant withdrew. And in the meantime, complainant had used a different text-to-speech program to complete his assignment. With respect to the taking the test on Monday situation, if we look at section 4, paragraph G, you know, it says that he was offered to take his tests on Monday. You know, and I'll just read during that meeting, manager, this is the meeting on September 19. During that meeting, manager allegedly assured complainant that if he remained in the program, he'd be allowed to take his exams on Monday with an in-person reader going forward. Complainant instead decided to withdraw from the ABSN program. So, you know, there's an interactive process here, and there's no credible evidence in the record to show that complainant didn't just sort of short circuit that before we could, you know, get to a point where whatever disputes were present were resolved. And so I don't see how there's a credible claim of discrimination here.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Thank the parties for their participation, and the commission will send a letter confirming the results of the hearing.
Next case is ED 240044, Christopher Nurick versus the state of Maine. It is a disability accommodation case. Recommendation of the investigator is for a finding of no reasonable grounds on the one count, and therefore we will hear from complainant if he wishes to make a presentation.
Good morning, Attorney Young. Do you want to reserve any of your time?
Yes, I'd like to reserve 2 minutes, please.
All right, whenever you're ready, go ahead.
I'm ready, thank you. Good morning, members of the commission. My name is Jeffrey Neal Young, and I represent the charging party, Christopher Nurick. There's no real dispute here that Mr. Nurick is disabled. The investigators recommended you dismiss Mr. Nurick's charge of disability discrimination, that he was denied a reasonable accommodation based on disability, because she concluded, first, that his claims were outside of the statute of limitations, and second, even if they were timely, that the employer did not deny him a reasonable accommodation because the state, A, didn't know it was violating his restrictions, B, Mr. Nurick could have auxed out or escalated calls to avoid exceeding his restrictions, and C, that Mr. Nurick never complained that his restrictions were being violated. I'll show that those are wrong, as well as the fact that Mr. Nurick was subjected to a hostile work environment. Turning first to the statute of limitations question, the investigator's conclusion is patently wrong that Mr. Nurick's charge of discrimination with regard to denial of a reasonable accommodation was untimely. Mr. Nurick filed his charge of discrimination on February 9, 2024. 300 days before that is April 15, 2023. As Exhibit A to our submission demonstrates, following April 15, 2023, from June 13, 2023 till May 1, 2025, or a period of about 23 months, according to the TAMS records, on no less than 37 occasions, Mr. Nurick worked in excess of his restrictions. So clearly the state failed to adhere to his restrictions multiple times, virtually 1.5 times a month within the limitations period. The investigator then goes on to state, for the complainant to establish that respondent failed to accommodate him, he needed to show that respondent ignored his work restrictions of knowingly placing him under conditions that violated the accommodation on or after April 15, 2023. We agree with that statement, so let me show you that the state both ignored his restrictions and placed him under conditions that ignored those restrictions. Let's turn first to the state's ignorance of his restrictions. To be paid, Mr. Nurick must fill out timesheets, or something called TAMS, recording his daily hours each week. Although the state has asked the investigator to rely on Mr. Nurick's call logs, those call logs do not accurately reflect how long Mr. Nurick actually worked on any given day. Mr. Nurick and all state employees are paid based on the time recorded in the timesheets. To be paid, Mr. Nurick's supervisor has to review and sign off on the timesheets. It's undisputed that on each of those 37 instances after April 15, 2023, Mr. Nurick was paid for the time on his timesheets as signed off by his supervisor. Thus, unless Mr. Nurick defrauded the state by falsely filling out his timesheets, which the state has never claimed, or unless Mr. Nurick's supervisors are claiming they didn't review the timesheets, which the state also has never claimed, the conclusion is manifest that the state was aware that Mr. Nurick was working in excess of his restrictions. Now let's turn to the second theory advanced by the investigator, that the state could be liable for violation of Mr. Nurick's reasonable accommodations if it knowingly placed him under conditions that violated his reasonable accommodation. That too occurred. Besides the fact that he worked repeatedly in excess of his restrictions, we have to talk about his job as an OIT specialist. That entails answering calls in a queue. As a general rule, the specialists remain in a queue until the end of their 8-hour shift, and they're expected to work before and the end of after the shift until a call is resolved. Mr. Nurik's providers initially allowed him 15 minutes of leeway until November 2023, when they limited his workday strictly to 6.5 hours a week. So how could Mr. Nurik have avoided exceeding his restrictions? I think there were three possibilities. First, the state could have permitted Mr. Nurik to leave the queue early before the end of his workday and do paperwork, but the record is clear that the state rejected that proposal. Secondly, the state could have permitted Mr. Nurik to AUX out, which would have also entailed him leaving the queue early. Mr. Nurik proposed initially that he leave the queue early, 7 to 10 minutes early, but the state rejected that proposal. And then in January of 2023, when he proposed auxing out and leaving the queue 30 minutes early, the state responded, this is a direct quote, "The end of your workday is 4 o'clock. Your job is answering calls. You can't stop working and continue to be paid," close quote. So despite these clear statements prohibiting Mr. Nurik from auxing out early, the investigator says erroneously that Mr. Nurik could have done so. She then offers a third theory that he could have escalated his calls, which is a little bit different than auxing out or leaving the queue. However, the state never formally suggested to Mr. Nurik that he could escalate calls as a reasonable accommodation. But even if it had done so, that would not have succeeded. In support of the proposition that Mr. Nurik could have escalated calls, the investigator points to a single email dated April 24, 2024, from Mr. Nurik's supervisor. That email, over a year after Mr. Nurik had requested and had been denied auxing out or leaving the queue, and also after he filed his charge of discrimination, was in response to a report from Mr. Nurik that he already had worked 6 minutes beyond his restrictions, and that he was getting another call, which would mean that he would work even further beyond the restrictions. And the supervisor's response was simply, quote, "Okay, comma, escalate it," close quote. Now, prior to that date, there's no evidence in the record that the state ever had suggested to Mr. Nurik that he escalated calls, despite the extensive back and forth between Mr. Nurik and the providers regarding his restrictions. This indication or offer that he escalate calls as a formal resolution of his need for reasonable accommodation was a one-time ad hoc suggestion. In addition, it wasn't really a feasible solution. Mr. Nurik's supervisor claimed he could escalate. It would only take 5 minutes. As the investigator says, Mr. Nurik disputed that. And contrary to the investigator who issued the report and who, by the way, was not the investigator who conducted the IRC, Mr. Nurik didn't just dispute that he couldn't escalate. There's evidence in the record, and the supervisor confirmed in writing, that to escalate a call, the specialist doesn't just transfer a call, but rather has to review prior tickets referenced by the customer to avoid duplication of work, take notes about the call before determining what the subsequent workflow should be, and then has to categorize the call. The escalation of a call, I'm sorry, okay, thank you. The escalation of a call is a multi-tiered, not a one-step process. Finally, the investigator suggests that he never complained, but on April 24, 2024, the record is clear that Mr. Nurik did complain. Finally, in terms of the hostile work environment, National Passenger Railway Corp indicates that you can take into account statements and evidence to support the claim that is within the period. And here there were multiple statements that we've referred to that are in the record. Thank you.
Commissioner, questions for Attorney Young? Yes, Commissioner O'Brien.
Thank you. Good morning. I've been
Good morning.
trying to visualize this process. And I'm not a tech person, and that's why I probably need him. But he's working remotely, is that correct?
Yes, that's correct.
Okay, and are all of the specialists working remotely? Or is there a little call center? I mean, is this how it's done?
I don't think there's any evidence in the record one way or the other in that regard.
Okay,
But
okay,
in general, they're all, whether they're in a center or working remotely, they're all in a call queue.
okay. Okay, so the call comes in and the next person in the queue picks it up. And then at what point is it escalated? What is the process specifically for escalation and oxing out? And I guess I'm
Well-
getting to the issue of the complainant says that the process to do that takes more than, the respondent says 5 minutes. And he says, no, it takes longer than that. Can you explain what that specific, is it just signing a ticket and saying, okay, what is that
Sure.
process?
So let me back up for a minute because you also raised oxing out, and that is different from escalating a call. Oxing out basically means that you leave the queue before the end of the 8 hour or whatever, however long the workday is, so that you don't wind up taking any further calls that would exceed your restrictions. If you're not restricted, then the expectation is that if you have a call that's going to take you over your 8 hours, that you complete the call. So hopefully that's clear. And that was one of the suggestions that Mr. Nurick made, was that he ox out early and that the employer said he couldn't do. Escalation is a different, in a sense, process. Escalation is that you're still in the queue, you have a call, it becomes apparent to you that the call is going to take you beyond the end of your regularly scheduled shift. And when you have to escalate a call, which, by the way, as I said, was only suggested on one occasion and was never part of his formal reasonable accommodation process. And I think this is in the record, we could probably find it. There's a sort of a flow chart or description of about a 7 or 8 step process that has to be followed when you escalate. But in general, you can't just say, I'm getting off of the call and I'm transferring it to another call specialist. What you have to do before you escalate the call is you have to review prior tickets from the customer to avoid duplicating the work that may have been done previously with respect to the call. And then you have to take notes on what the customer, essentially what the customer's complaints are, and pass those notes, then go on to the call specialist who is going to be taking the call. And then there's what I'll call a categorization process that has to be followed. So that's the general outline, I think, of escalating a call. I know that the supervisor claimed that it could be done in 5 minutes, and as the investigator found, Mr. Nurick consistently disputed that. But besides the fact that it was never formally offered except on that one occasion, as I indicated, there is a whole process that's set forth in the record that indicates what it would take to escalate a call. And I think the parties candidly just dispute how long that would take. Does that answer your question to the best of my ability? Thank
Yeah.
you,
Thank you.
Commissioner.
Any other commissioner questions for Attorney Young? Seeing none, you'll have a little more than a minute left when we come back to you.
Thank you.
Want to reserve any of your time?
I'll reserve 2 minutes, please. Thank you. Good morning, Commissioners. My name is Kelly Morrill, Attorney General, and I represent the state of Maine. Investigator O'Reilly her report was spot on in this case, and the commission should adopt her recommended finding of no reasonable grounds here. So the first issue is the statute of limitations. The law court and First Circuit precedent are both very clear that denials of reasonable accommodations are discrete actions and not properly considered under a continuing violation theory. So it can't be tied into a hostile work environment. The clock starts running when the initial denial is made, when the employee has unambiguous and authoritative notice that the request has been denied. And in this case, Mr. Nurick requested that he opt out or log out of the call queue 30 minutes before his end of shift back in January of 2023. That's in the record. So his charge with the commission should have been filed in late October, early November of 2023. It wasn't filed until February of 2024. So he appears to be arguing that each time he allegedly was required to work over his restrictions, a new clock started for the statute of limitations. The law court in Keyser versus Central Maine Medical Center flatly rejected that argument. That's what the plaintiff argued in that case, that each time he renewed his request, and they denied it, that started a new clock. And the law court has specifically rejected that. So his failure to accommodate claim is barred by the statute of limitations. So anything even within that 300 days of him filing the charge shouldn't be considered here. The initial denial was in January 2023. With respect to the separate hostile work environment claim, the continuing violation theory can be applied to that. However, everything he's alleging that was done to him by HR manager CC was still outside the statute of limitations, and there's no anchor event within the statute of limitations to apply the continuing violation theory here. And so the investigator appropriately dismissed the hostile work environment claim, the separate hostile work environment claim. So I'm going to address the merits anyway, even though I think the whole claim is barred by the statute, because the investigator did address it in the report. And so you may have questions on it. So just to address Mr. Nurick's initial claim that he opts out of the call queue before his shift is over, he asked to opt out at one point 30 minutes prior to the end of his shift. His job is to be in the call queue all day, other than break times. So that's his entire job. So it's unclear what he would be doing if he opts out of the queue 30 minutes early or even 15 minutes early. So that was denied. We agree that the option to escalate calls was not formally put in writing, but during the Issues and Resolutions Conference, it was stated that he was told that he could escalate calls. And we do dispute how long it takes. So we submitted a sworn declaration from his supervisor that it should take about 5 minutes. So the option was if he was on a call, maybe 5 to 7 minutes before his shift was scheduled to end, he could escalate the call. So it starts with telling the caller, I need to transfer the call to somebody else. He needs to fill out a ticket, and this is in the record. This is an escalation ticket, nothing elaborate. It's just a general description of who the caller is, what the problem is, and this goes into the system. He also has to type into the Teams chat that he's going to be transferring a call to somebody on the escalation team. And then if no one's available on the escalation team, he would go back to the caller and say, no one's available, someone will call you back. That's it. So there's nothing in the record that suggests that he even tried to do this. Investigator O'Reilly asked him directly if he had tried it as an accommodation, and he didn't respond to the question. So he can't say now that it wouldn't have worked because he didn't try it. We say that it would have worked. So escalation is the most effective accommodation because auxing out would only work if he was not on a current call. So if it were 5 minutes before the end of his shift and he wasn't on a call, fine, aux out. But you know, where do you draw the line here? 30 minutes before, I'm not on a call, 15 minutes before. So he's got to take calls up until almost the end of his shift. So, you know, we would submit that escalation was the answer here.
Oh, sorry.
Just a pause, I guess. Just to address the fact that he's claiming that he continuously worked over his restrictions and that his TAMS timesheets are different from the call logs. They are. We submitted the call logs. His whole argument for auxing out was that he was getting stuck on calls and working over his restrictions. That's not true. I analyzed the call logs, and there were only 2 occasions within the 300 days where he worked 6 minutes over and 7 minutes over. The rest of the calls, he was out of the call log. So he has extra time on his TAMS timesheets, but it's unclear what he was doing after he logged out of the call queue. And we're not accusing him of anything, but his supervisor did say in the declaration, I don't know what he would have been doing if he weren't in the call queue. And all Mr. Nurick has said is paperwork. And we're not aware of what paperwork he would have been doing because generally it takes about 2 minutes to do a ticket. And they're required to do tickets after each call before they take the next call. So the only paperwork that would have to be done after the last call is the 1 ticket for the last call. So, and there's also a difference between requiring someone to work over their restrictions and allowing them to. We can't force an employee to take an accommodation. And if he chooses not to take the offered accommodation and works over his restrictions, that's not disability discrimination or a failure to accommodate. He knows what his restrictions are. And I would say that it's not up to his supervisor to keep telling him, you can't violate your restrictions. You can't do this. You have to take this accommodation. And we're certainly not going to discipline somebody for not taking the accommodation. I think we would do that. We didn't in this case. His supervisor was reviewing his timesheets, taking his word that he was working. The supervisor at that point may have assumed that he was in the call queue still and decided to take the call past his quitting time. So I would urge you to adopt the investigator's recommendation here and find no reasonable grounds and dismiss the claim. And I'm happy to take questions.
Okay, Commissioner David, thank you. We'll just go down the line.
First of all, Attorney Morrell, thank you for taking the time to come personally. It really adds to it helps me with my hearing deficit and adds to my ability to understand. Do I understand that it was an accommodation to tell him that he could escalate a call even though he didn't need to technically? In other words, it wasn't beyond his area of competence. It was 3 minutes of 4, and he had that option as an accommodation to say, I'll kick it up so I can go home on time. Is that correct?
Yes, the escalation policy is there for everybody in certain circumstances. So, right, exactly. Exactly.
Can't handle it here, or I can't handle it with you. You need to be on site, or blah, blah.
Yes. So the accommodation was for him to do it just because he needed to leave.
Right.
Yes.
In the report, in that request in January of 23, which we have this issue about being barred, he asked to leave his shift at 3:30 every day, that he'd be off and still be paid for half an hour. And they deny that, and then the report says that he could be allowed, that the response was complaining to have a 15-minute cushion to resolve calls. Was that 15 minutes? In other words, isn't that saying that he could leave the queue at 3:45?
No.
Was that done? Was he given that?
No, so the 15-minute cushion was actually given by his doctor. At the time, he had a restriction that he couldn't work over 8 hours a day, but he could work 15 minutes over that ad hoc if necessary. So if he was stuck on a call, he could go over by 15 minutes occasionally if he had to. So the doctor made an allowance for that.
is it clear in the record that the call log recording time, that the time would include the time to escalate or the time to write whatever summary you write of the call?
Yeah, the call logs
And
reflect.
then you end the time of that call.
Yeah, the call logs reflect the time he logs on in the morning, the time he logs out for breaks, time he logs back on. So it's every time he logs in and out. That's the call log. The system automatically records everything. So if he were to escalate a call, we'd say like 5 to 7 minutes before the end of his shift, if he thinks it's going to go longer, he would tell the caller at that point, I need to transfer this, let me do a ticket, to give himself enough time to do it so that he doesn't go over his restrictions.
Commissioner O'Brien?
Thank you. Again, I'm a visual person. And so what happens if, well, I assume the bathroom breaks are not scheduled bathroom breaks, or are they?
No.
Okay, all right, so,
No.
so what happens when when he needs to go there? Is it everything put on hold, or is it passed on, or how does that work? Passed on to another person, or how does that work?
Well, there was testimony at the Issues and Resolutions Conference that all of these callers, the system support specialists are told, if you have to leave for any reason, not just bathroom, but if you want to get a cup of coffee, whatever you want to do, you just type into the chat BRB, be right back, so that the rest of them know you're not there, and you can get out of the queue. If he's on a call, I think
That's what
he's got to finish the call.
That's what I mean.
Most of them have to finish a call. I mean, if they put off leaving, I would think if they really have to go to the bathroom or something, they could probably escalate the call in that case.
So that would be an escalation.
I think it would be.
Okay.
I think it.
And is there, I think I mean that there is a special escalation team.
Yes.
Okay.
Yes.
All right. So it just
Yes.
doesn't go to another.
There's an escalation team, and they have to be available. If they're not, then they call the person back.
Okay.
Whoever's
Right.
available.
Right. Got it.
Yeah.
Commissioner
Just
Douglas?
going down. Good morning.
Morning.
So on the timeliness piece, right, the argument about the denial of reasonable accommodation, I'm with you on that. I'm looking at Attorney Young's statement of disagreement, and he's got a litany of things, the other hostile environment thing I think you're referring to. He's got a litany of things that he claims support a claim for hostile environment. These statements, for example, I no longer am sure you have one or more serious medical conditions as defined by the regulations. Another statement, given the documentation from complainant, I think we have to approve his request.
Yeah.
And there's very little, really nothing that I am aware of that we could do to push back on it, right? Things of this nature.
Mm-hmm.
My understanding of your argument is that there's no anchoring event for this claim of a hostile environment that would make this claim timely. I just want to make sure I'm understanding.
Correct. There's no anchoring event. I would also say that that's not severe pervasive harassment either. Our position is that the HR manager was doing her job by checking his paperwork, making sure she had the right paperwork. That statement that was made about not much we can do to push back. I think what Investigator O'Reilly said in the report is true. It's acknowledging a supervisor's frustration with intermittent FML. Whenever intermittent FML is given, they have a job to do. Someone's reducing their schedule. They're frustrated. But he was never denied any of his FML.
Okay.
He got all of it.
And then between the call logs and the timesheets, right?
Mm-hmm.
So Attorney Young's argument at trial, I think, is going to be, he filled out these timesheets. They show on 37 different occasions, whatever it is, that he's working past his restricted time, right? And he was paid for that. He submitted his timesheets and he was paid. Nobody said anything, right? The call log shows something different.
Correct.
And my understanding, based on what you said just now, is that at trial you're going to maybe sort of suggest that I don't know you're going to go as far to say it was fraudulent, right? But you're going to say that there's a problem here because what could he possibly have been doing?
Correct.
But after you paid him already, though.
Oh, we have to pay people. I mean, they took him at his word. He submitted his time sheets. Maybe the supervisor should have questioned it. I don't know. Right. But when the supervisor is reviewing the timesheets, he doesn't have the call logs in front of him either. You have to print out the call log to actually see what the times were. And that's what we did for this case. So the supervisor doesn't have the call log pulled up to see, when is Chris Nurek working here? Does this match with his timesheet? They took his word for it that he was working. The supervisor may have thought that he was still in the call queue at the time and just had decided, to take the calls, because he didn't want to escalate the call. I don't know, but
the timesheets, I'm sorry to cut you off,
No.
but the timesheets show that he's working
worked.
more than his restricted hours.
correct,
Signed off on repeatedly
by his
the state,
supervisor.
right? So I guess I'm just wondering, isn't that a problematic factor you would try?
I do not think so.
Okay.
I think that, again, there's a difference between requiring somebody to work over their restrictions and allowing them to. And he knows what his restrictions are. He should be adhering to his restrictions with the tool that he was given, escalating the calls. And
Which the
If he's
evidence
not-
for is little read in terms of what he was told, how he was told, right? I mean,
Right.
it's an affidavit
but again,
after the fact.
his argument was, I'm working over my restrictions because I'm getting stuck on calls. He was not getting stuck on calls. So what was he doing after he got out of the call queue to make him violate his own restrictions? I think that would be our cross-examination of him, probably.
Right, thank you.
Commissioner Sanders?
Did the heavy lifting.
Yeah.
No, those were substantial. Again, thank you for.
Yes.
You'll have about 2.5 minutes left to make the next.
Thank you.
Attorney Young, you have 1 minute and 11 seconds if there's anything you'd like to add. And if I could just
Yes.
ask, I don't know why, if you could just speak up a little bit. We've got the volume turned up pretty high on our end. So if you can just get a little closer to your mic, that'd be helpful.
Will do. First of all, with regard to the January 2023 date and the statute of limitations, yes, Mr. Nurek may have been granted an accommodation at that time, but he wouldn't know until afterwards that the state was actually implementing the accommodation. And that's our whole point, that there were 37 instances after the state claimed to have implemented the accommodation where it didn't do so. In terms of the escalation issue, again, there's no formal documentation in the record. The supervisor submitted an affidavit. There was no opportunity to question him. Mr. Nurek clearly denied that he was ever told, except on that one instance, about escalation. Again, he was, as Commissioner Douglas, I think, pointed out, the call log is not the reliable record. The reliable record is his TAM sheets, which were never questioned. Mr. Nurek had to do substantial paperwork after any event, and that's why he was working beyond. It wasn't a matter of allowing him.
That's your time. Attorney Young.
Thank you.
Any further commissioner questions? Yes, Commissioner David.
Are you, in those 37 times, does he complain that he's being forced?
Well, he
Attorney Moore
definitely.
said the difference between voluntarily working overtime to finish a call or being required to. What's your argument that he was required to? What documentation is there of that, if any?
There's documentation in his note of April 24, 2024, in which he said, I'm being required to work after my time, and I'm already 6 minutes over my time. In my mind, that's a complaint, and that was the single time that Mr. The supervisor, I can't mention his name, said to go ahead and escalate.
Where does that go, that complaint? He's working 6 minutes over.
I'm sorry, where does that go? He voiced it to his supervisor, and then there's an email about it.
And that's the only time that he alleges that he complained.
He complained about having to work beyond his restrictions on multiple occasions, but I think that's the only documentation, Mr. David.
But the important operative word there is having to work You're saying that he was required to, in violation of his medical condition.
Well, because the employer was aware that his restrictions were that he only work X number of hours a day, and yet he's repeatedly 37 times working beyond that. And he,
But it's an
there's all this.
interactive process.
Yeah, and there's all this back and forth about him complaining about, making suggestions about auxing out and about, and which the employer rejected, which, by the way, the 30 minutes was not in January. That was before that. January, he suggested 7 to 10 minutes. So there's all this back and forth about his suggestion, and there's nothing in the record except for that one instance about escalation.
And my last question is the continued back and forth is in your view, is creating a hostile environment.
It's not the continued back and forth. The hostile work environment is reflected by the statements of the supervisor questioning that he actually has a medical condition that's a serious medical condition. And contrary to Attorney Morrill, he was threatened and at least on one occasion did lose his FMLA time. So that forms part and parcel of the hostile work environment combined with the fact that there's these 37 occasions which do constitute anchoring events under Morgan versus Jefferson Morgan versus National Passenger Railway Corp.
Thank you.
Thank you.
Yes, I just wanted to give you a chance on the timeliness issue to respond to what Attorney Morrill said, particularly with respect to the allegations in your statement of disagreement on pages 8 and 9. Or I'm sorry, 9 and 10. Basically the statements that I had recounted for Attorney Morrill. I'm no longer sure you have one or more serious medical conditions. Given the documentation from complainant, I think we have to approve it, and there's very little, really nothing that I am aware of that we can do to push back on it. And I think her argument was twofold. First, she said this is not enough to support a hostile environment claim, and there's no anchor event to make this claim timely. And so I do see your footnote 10 here, but I just thought it'd be helpful if maybe you could respond to that.
Sure. Thank you. Yeah, I mean, the anchoring events are the multiple occasions after April 15, 2023, those 37 occasions, where Mr. Nurek worked in excess of his restrictions. And Attorney Morrill has suggested that those should be treated, and I think the investigator used the word discrete acts, and you could call those discrete acts if it happened once or twice, but when it happens repeatedly, it becomes part of a pattern. And so you then also, as I said in footnote 10 there, you can go back and look to the statements that were made outside of the period to show whether there is a hostile work environment. And so that's why we point to those statements. As I think I said in my submission, until this new supervisor, CC, came along, there had never been any issues with Mr. Nurek getting the accommodations that he needed and being able to comply. It was only when CC came along, and as she said in response to the investigator about how come everything was okay up until her, she claimed that the other HR personnel had been, quote, lax and overly permissive, close quote. I also wanted to point out, I think this is responsive, and I mentioned it in my submission that in his charge of discrimination, Mr. Nurek did not simply say that it was the quote unquote calls that were requiring him to exceed his restrictions. He went beyond that, and it's in his charge of discrimination, and said that it was the totality of what he was having to do, not just that he was being required to stay on a call in excess of his restrictions. And I think that's important to note. Thank you.
Is the record clear? This discrepancy between the call logs and the timesheets, right? I mean, I think you heard Attorney Morrell say that at trial, they're going to suggest that there's something funky about him working this additional time. What was he working on? Right? I mean, these are the questions he's going to be subjected to at trial. And I'm just wondering, what is he going to say if it's in the record? What was he doing?
Just really quickly, so that question was asked. Depending on the details that the attorney now provides, some of that would not be in the record. And I can address, I'll let him answer, and then I'll address what is and isn't in the record when.
Okay, thank you. Yeah.
I'm sorry, who was that was speaking?
Go ahead and answer. You're fine. Yeah.
That's your investigator.
I don't think there was any question raised about what he was doing during that time, because the state paid him for that time, and he's repeatedly, I'm not sure what's in the record or not in the record at this point, but he would say that he had additional paperwork that he needed to perform. All of these calls require some paperwork, and some of the time so I think that's the best answer I can give you.
Okay. All right, thank you.
Any additional questions for Attorney Young? Seeing none, Attorney Morrell, you have 2.5 minutes left.
Just wanted to address a couple of points that Mr. Young made. The first one is that I think he said that Mr. Nurek was given an accommodation in January of 2023 and that he wouldn't have known whether it would work for purposes of the statute of limitations. That's not our argument. Our argument is that he denied his requested accommodation in January of 2023, and that's when the clock started running. So for purposes of his discrimination claim. So at that point, he knew that he could not opt out in advance of his quitting time. The second one is, with respect to your question, is did he complain? If he had complained, we would have said escalate the calls. That was the answer.
You would have said, yeah.
Not me, but yes, they would have said
He would have been
escalate the calls. Yes, escalate the calls. If you're working over, escalate the calls. As far as the anchoring events, again, I would say that failures to accommodate are discrete actions. That's the Keyser case completely. So those should not be considered in the context of a hostile work environment. So there is no anchoring event for that claim. And again, I want to reiterate, he absolutely did not lose FML time. He was not denied FML at any point, even when they were trying to get paperwork to substantiate his request. He was able to take the FML anyway. So he did not lose FML at any point. And my recollection as far as what is in the record about what he was doing was that he said he was doing paperwork. And again, his supervisor said, I don't know what paperwork he would have been doing. The ticket would be the only thing, the ticket for the last call. So again, we don't know exactly what he's doing.
Commissioner, questions for Attorney Morrell? Getting none, thank you both. Next we'll hear from Jane O'Reilly, who completed the investigation.
Morning, commissioners. As Kit said, my name is Jane O'Reilly. I was the investigator on this case, not the initial investigator, but I did actually complete the investigation in this case to the extent that's relevant, and draft the report. I'm going to focus on the facts and the reasoning that I based my finding on, because I think we've gotten a little bit away from what facts I, as the investigator, thought were crucial for making the finding that I did. And I'm going to put aside all the timeliness issues because I think, again, if we decided it was untimely, it would all be moot. So I'm just going to argue on the merits, but I can certainly address any questions you have about timeliness. So this issue of a reasonable accommodation request is based on whether or not the accommodation is going to allow the employee to perform the essential functions of their job. What was not clear, based on this discrepancy between the call logs that were submitted and the timesheets that were submitted, neither party disputed either, right? Complainant wasn't saying, no, those call logs aren't accurate. Respondent wasn't saying, nope, those aren't the hours we paid him for. I don't know why they're not reconciled. And neither party could tell me why they weren't reconciled. But what's important is that the accommodation that he requested was to get out of calls early. There's no evidence that getting out of calls early would have stopped him from having so much paperwork. Basically, there was nothing provided by his supervisor, by his job description, by anything that indicated there would be so much paperwork associated with being on these calls for OIT. Your hours were paid from when you logged into the call queue until you logged out. You worked those 8-hour shifts. So because those can't be reconciled, I went based on his request for accommodation, what it was, whether or not the denial of that was occurred within the 300 days, and whether or not that affected the terms and conditions of his employment. So firstly, I found that it wasn't denied within those 300 days. And second, I found that the denial of it wasn't affecting the terms and conditions of his employment because there was no evidence in his call logs that he was repeatedly, all of the time, under conditions that he couldn't have, again, escalated a call or oxed out a few minutes early, forcing him to work past those restrictions. I'll also talk about those processes. So the escalation process, I actually described in paragraph D of the facts in the report. So that's my understanding of how to escalate a call based on the record. Even though complainant disputed how long it would take, he didn't dispute the steps. So that's essentially what the steps are. And escalation, as you identified, is a common practice for complicated calls. So it's not a practice he would have been unfamiliar with. It's not something he would have to learn. You know, escalating a call would be an easy thing for him to do if he needed to get out of the queue. Auxing is used for breaks. So if you need to step away for a minute, if you need to pull yourself out of a call, sometimes if you're on a complex call that you resolve, it might take you more than 2 minutes to do the ticket. This was all provided by the supervisor in the information they provided in the investigation. You might need to step out of the queue for a few minutes to finish up that ticket, and then you'd come back in. So auxing was also something that all the OIT specialists would be familiar with. So the issue here was really the dispute around complainant wanting to ox out so much earlier, being denied that, and then the communication kind of dropping off. And it wasn't clear to me that there was any clear communication from complainant beyond that point that he was being forced into conditions that would put him past his restrictions in the call queue. Again, I don't know why his TAM sheets are different. Complainant was provided multiple opportunities in the investigation to provide what he was doing. He only ever said it was paperwork. Respondent couldn't respond to that. They were not aware of any paperwork that would cause him to work 45 minutes past his restrictions. So that would be something else to resolve later. But for the purposes of what I was analyzing, denial of reasonable accommodation, it seemed that that discrepancy wasn't enough to support that respondent was putting him under conditions or denying any recent accommodation requests. Hopefully I didn't talk too fast. Let's see. I had a few notes about the hostile work environment claim. So I addressed some of that in the footnote 7. I didn't footnote 7, that's on page 4. I didn't specifically talk about it in relation to a hostile work environment request, but I did talk about one of the comments, which has been attributed to creating a hostile work environment, which is that, I think we have to grant this. I'm so sorry. I don't see any reason we can't. Again, I did not see that as severe and pervasive conduct, especially as a single incident. It wasn't said to complainant. It was a piece of information that was completely between the HR person who was trying to evaluate the request and the supervisor. So it wasn't as though complainant was, being told this is a big burden, you're putting pressure on our agency. That was something, between those two individuals. And the other comment about, I'm not sure you still have, I forget exactly the words, disability that qualifies. That statement wasn't made offhand. that was as part of a larger email. That's like the record is this big. I couldn't find the email, but it's part of an email that the HR individual at the time was sending to complainant about a request for more paperwork. So it wasn't, again, this sort of like, stop asking me questions. I'm not sure you have anything. It was, you're asking for new things. It's been a while since you asked for things. We need updated FMLA. Like, it was part of a larger context where she was justifying her reason for asking for that additional information. So based on that context, I also didn't feel that statement rose to the level of a severe, pervasive, hostile environment. Again, putting aside timeliness issues of whether or not, we can analyze those within the time frame. So I think that's all I had based on the questions that were asked in the presentations, but if you have any more questions, I'm happy to answer them. Yes.
Thank you, David. I am curious about footnote 7. I understand the observation that, this particular remark, pushing back, remark in and of itself, right, is not sufficient, severe, pervasive to establish, a claim for a hostile work environment. I'm curious though, I mean, it's a curious turn of phrase, right? And I wonder, couldn't we see it as evidence of an attitude, right, that undergirds how the HR representative and the supervisor are going to be working with the complainant? And so through that lens, isn't it reasonable to interpret all of the other conduct, right, that Attorney Young articulates in the statement of disagreement? Couldn't we similarly view that as evidence of this attitude that undergirds how are they approaching complainant? How are they manifesting their intent, right, to apply FML in a way that's consistent with the law? And so can you just respond to that?
Sure. Are there specific statements you're thinking about in the submission disagreement about?
Yeah, it's on the, I think it's on page 10 of Attorney Young's document. Let me see if I can get it.
Oh, are you talking about the first paragraph? CC audited Mr. Nurk's use of FMLA on multiple occasions. Okay.
That's right.
So obviously you guys can see it however you want. So I'll just preface my answer by that. The record is very long. It took place over many years, and there is definitely evidence that complainant did not like this particular HR person. I would disagree based on my reading of the record that Attorney Young's characterization in that paragraph is correct. I do not believe that complainant was audited. I do not believe, based on the record, that he was, repeatedly asked to provide in excess of what was necessary documentation to support his need for disability. That statement is unfortunate. It's unfortunate that, complainant saw it and those things, but again, this idea that in discussions of, for example, this statement was made in response to a supervisor who was trying to say, "Do we have to?" Right? Like these are out of context statements as complainant counsel is now presenting them. They are part of a discussion that an HR person is trying to navigate between, protecting as much as they can, the sort of needs of an employer, balancing with the needs of an employee who needs an accommodation. So, I've read a lot of accommodation cases. I've read a lot of cases with requests for FMLA, and nothing in this case stood out to me as the type of thing that would evidence this was, overly frustrating for respondent or any of those things. And even if so, again, the severe and pervasive conduct or evidence of bias and things like that are statements that that rise to the level of severe or pervasive conduct. So even offhand comments about, frustration about things like that, to reach that level for that type of claim, nothing in this record supported that to me. I mean, those are the only statements. I mean, the statements that you are reading are also the only ones.
Many years.
Over many years. Yeah, and he, was a longstanding employee, was still employed at the time that I wrote the report. Like, there's no evidence that he's never been, he wasn't disciplined for anything surrounding this. And as Attorney Morrell correctly pointed out, he was never denied any of his FMLA requests. There was nothing to suggest to me that there was bias in that.
Any other commissioner questions for Investigator O'Reilly?
Thank you.
We've heard from the parties and the investigator. At this time, we are looking for a motion. There is one proposed. Commissioner O'Brien, sorry, I lost my words for a minute.
I propose to agree with the report that there are no reasonable grounds to believe that the state of Maine discriminated against Christopher Nurick on the basis of disability, and that complaint should be dismissed in accordance with 5 MHRC 46122.
Second.
Moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
The findings are no reasonable grounds. The commission thanks the parties for their participation and will send a letter confirming the results of the hearing. Do we have a 5 minute?
Sure, we'll be in the recess to 5.
Talk about
You mute us.
yes.
You all set, Jane?
Now you're good.
Next case is PA 24-0054 George Stanley versus Paris Farmers Union. The recommendation from the investigator, it's a public accommodations docket number, is for a finding of no reasonable grounds, both on discrimination and retaliation of the 2 counts. And the recommendation is for a finding of no reasonable grounds. There, we would hear from complainant, who does not appear to be online. Is
there anybody on the Zoom call for Mr. Stanley? If there is, you can unmute yourself now. He is not here in person, which is what we were expecting.
So for the record, he's not not in the room and not online. And we
generally here
to a motion.
Yes, in cases like this, we would usually adopt the investigator's report. Investigator O'Reilly is here if you have any questions for her. Or we can
I'll move to that we find that there's no reasonable grounds on both counts, no reasonable grounds to believe on one discrimination on the basis of disability, and no reasonable grounds to believe that there was retaliation.
Moved and seconded. Any discussion?
Well, just a question. It's public accommodations because it's a store that's open to the public.
Yes.
But it's the same analysis about disability discrimination.
As it would be in the employment.
Yeah, as there would be in
It's similar anyway, yes.
Okay.
Any further discussion? Seeing none, the motion is to find no reasonable grounds on both counts. If you're in agreement, you will vote yes. Commissioner Davis?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
The findings are no reasonable grounds. I appreciate that the respondent was here, and the commission will send a letter to the parties confirming the results.
Thank you.
Thank you.
The next case is a PA 24-0071 A and B, Kristen Price versus Boys and Girls Club and YMCA of Waterville and Alfont Youth Center. The recommendation is for finding of no reasonable grounds, and therefore we would hear from complainant.
Price, you have 10 minutes. Do you want to reserve any of that time for rebuttal?
Whatever is left after I do my statement.
Whenever you're ready, go ahead. If you could speak up, you're a little quiet and a little echoey.
Okay, sorry. Just gonna turn down the volume. Can you hear me? Is that better?
Yes.
Perfect. Okay, great. Well, thank you for your time.
Oh, no, hang on. I don't know if you have another device on, if you can.
I do. I'm sorry. I'll come in for my tablet. I apologize.
Sorry to interrupt. My name is Prosper, and I think I might be joining in late.
We will not hear your case for quite a while, sir.
Okay.
Sorry, opening it.
No. Can you leave the meeting with whatever other device you have?
The wrong one.
Whoops. Well, I have another Kristen text again, so let's see.
All right, Ms. Price, let's try that one more time.
Is that better? Sorry.
Yes.
Awesome.
I gotta
Just move this one over. Okay, I apologize for that.
All right.
But thank you for your time. The date of the incident that started this event was January 6th at the AYCC. I asked a clarifying question as to where I should sit safely after being instructed to move. and the question was directly related to my disability and my ability to safely access the facility and that gym that day. Rather than engaging in a conversation about where I could sit safely, I was repeatedly confronted, threatened with removal, and discouraged from asking further questions. At no point during this interaction did any staff member ask whether I required an accommodation or an attempt to identify an accessible seating option. If there was accessible seating that existed, the staff should have directed me to it when I asked where I should sit safely. Instead, no accessible seating option was identified and no discussion about my uh, my need for a accommodation occurred. My request was not for special treatment, but to simply clarify regarding safe sitting so I could watch my child's game. My statement of events shown through a private message between another parent and AYCC employee present at the game. The dialogue correlated and substantiated my timeline and actions on the day. The employee did not correct any statements that I made. Instead, they apologized that I had to go through that. I provided images that show me sitting at the timetable as directed by P. Garrett. The AYCC and the MHRC investigator have stated numerous times that I was seated with my son's team. That is incorrect. I never sat there. I supplied the AYCC and all parties, as well as the MHRC, with employees involved, as well as their contact information. There was no statement provided from any other AYCC employee beyond P. Garrett. They stated that the game was in play before P. Garrett spoke to me. That is incorrect. It was just before the game tip-off. He stated I was the only person not complying. That is not true. I immediately complied, but I am the only person that asked a clarifying question on where to sit. They stated that P. Garrett stated his position at the AYCC immediately, which is not correct. He simply said, I work here. He did not disclose his position until I stated I would just email my concerns after I had been accosted multiple times and threatened with expulsion. The clarification on his position as a point of intimidation occurred. When I said I would email, he said he wanted me to know any issues that I have are irrelevant because they will come directly to him. Well, I did decline to take his hand stepping down. It's my right to do so. It doesn't mean that I don't have a disability. They stated that there is a handicap seating available on the ground level and in a separate area. That is not true. As of February 2025 and up until today, there is still no handicap seating available at the AYCC. If accessible seating existed, I should have been directed there. I never stated that the AYCC should anticipate my needs. I simply asked where to sit. Live Barn was not an option that day as it was a paid member subscription to be pre-planned in advance. So there was zero seating in the lobby that I could see the gym, and there was no virtual way to see the game. The absence of designated accessible seating combined with the failure to engage in discussion after repeated accommodation requests effectively denied me equal access to my child's games and to the programs offered in the facility. There was no offer of accommodation during the season of this event, basketball 23-24. There was no accommodation offered the next season of basketball 24-25, although requested in writing to all parties on December 11th, 24, in which I stated that the placement of my son's games and practices in Gym 2, the gym in question, was retaliatory. And I, in bold, said, I am asking for an accommodation of this seating that I can sit safely. And there was no response. I again requested an accommodation this year for the 25-26 basketball season. And there was an email from the athletic director that read, happy to make sure you get the accommodation you need. Games have been moved by Brandon to courts 2 and 3 for the season. And I'm happy to report we had the bleachers redone so that there will be more distance between you and the court during games. The AYCC has refused to productively cooperate at all. The actions of both P. Garrett and the safety officer on that day were in direct violation of a communication guideline sent that very morning by the athletic director, Beth LaFontaine. Subsequently, Picoret and the safety officer should have been aware of these guidelines. And furthermore, Beth was present and party to the situation as it occurred, but she did not rectify or address my concerns until December 11th of 2025. I never demanded to stay on top of the bleachers. And this is an issue that started with one employee at one game, but it has grown into an ongoing blatant disregard for invisible disabilities. My private conversations were highlighted as being vulgar after explaining that code switching is how you change the way you dress or speak depending on your audience. Hence, when I am around children or in a business or professional setting, my vernacular I use is different than private dialogue, which represents a more free and open expression. None of the dialogue that I made was party to the actual events that happened. It was just an explanation of it to a friend. In closing, AYCC has refused multiple times over 3 seasons to productively cooperate at all in any discussion of accommodation. In addition to my multiple requests for accommodation, I also communicated on May 13th, 2025 to all parties that I am looking to obtain resolution through this process. Again, that went unanswered. And while the AYCC has ignored me completely, they have not forgotten about us. And I make that statement confidently as the AYCC has used an image of my husband in marketing since that day. They have used him to drive new membership and in a hiring marketing. My child also works there. They have made physical changes to the bleachers for seating safety while paying an attorney to state that there were no safety issues at all regarding the bleacher placement. Overall, it could have been one employee making a mistake, rectified via accountability and communication. It has turned into a disregard for invisible disabilities. Over the course of the complaint, the AYCC has shown disrespect to the rights of their community and disdain for invisible disabilities, as well as the lack of follow through to the MHRC and its processes. As a place of a public accommodation, the AYCC is required to comply with the Americans with Disabilities Act of 1990 and the Maine Human Rights Act. Under these laws, individuals with disabilities are entitled to equal access to programs and services and reasonable modifications when necessary to ensure safe participation. Organizations must also engage in an interactive process when a disability-related need is raised. That never happened. So I'll finish that. And I appreciate your time and I am open to any discussion. Thank you.
Commissioner O'Brien.
Good morning. First of all, I said in the previous case that I have pictures. I deal with pictures in my mind and I can picture that gym because I've been to many, 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 many games that way. So I guess I have 2 questions. One is when you talk about being on the top of the bleachers that were folded in, correct?
I did was that on top of the bleachers in the space. I actually do have a picture that was provided to show where exactly the seating happened. I'm sorry, I'm just trying to dig through all of it. So while I was seated on the top of the bleachers, here's a picture from January 2020 of a basketball game in the AYCC. I'm not sure if you guys can see it. So it's January 20th, there's a basketball game in the AYCC. You can clearly see at the top that there are multiple people sitting there at the top of the risers. So this was in 2020. Up until the day of January 6th of 2024, that had been allowed and okayed for seating, which is why I was there. I immediately complied when I was asked to get done.
Okay. Again, the rest of the bleachers were pushed into the wall, correct?
There was only
the bleachers were in so that there were no steps up until the top. Is that what you're saying?
This is one bleacher that you can sit on.
Right.
And then it was a step up to the top. So, but yes, there was one bleacher here, which is you're supposed to sit here underneath an active basketball hoop, which is why at this time and up until this time, people had sat up at the top.
Right. Okay, all right, it's different than I pictured. Okay, thank you. The second one is, again, knowing that tight space. And you said, I think you said there were 3 courts in the room. Am I correct? There were 3 games going on, or?
Each game is compartmentalized by a fabric barrier between the courts.
Right. So I guess where would, they offered you a couple options. How would you have proposed? What would have been a safe seating accommodation? What could they have done?
The options that I was given on that day were 3. 1, I could sit in the lobby and watch via Live Barn, but it was a subscription that was not a viable option. 2, he told me I could sit by the team on their bench. And the third option was to sit at the timetable in the back by where I did put in a image into evidence that showed me sitting by the timetable. That's where I sat. This could have been handled better if I wasn't repeatedly addressed mid-game, and if there was any conversation after the day of the incident from the AYCC. There was not.
Okay. I get you're going on where I understand what you're saying, but again, where would you have proposed? What could they have done?
Again,
I know there was ongoing confrontation.
There was no place for me to sit that was not in danger of being hit by a ball, period, that day. There's not. The bleachers were 1 seat behind active baskets. I was told to sit all the way to the left of the basket by the table. I was told later on in my conversation that was the handicapped seating area, because you could come in with a wheelchair and seat both games, but you are still in the vicinity to be hit by a ball. Now, I do believe, sorry.
Go ahead, finish your thought.
My statement, the changes that the AYCC has made to the bleachers, which have increased the seating exponentially, could have been easily made into an accommodating space through conversation with me, through a sticker on the wall next to the bleacher where there is metal on the side that could block. If there could be a sticker there says, please reserve for our friends with handicaps. There is a way through conversation that the accommodations could have happened. I was not adverse to it.
This is not in the record. I think this sort of like what could have happened. The investigator is that's not in the record.
What is not in the record? I'm sorry.
Your suggestions for what could have been done, that those are not in the record. Okay.
They're not in the record because I was never actually addressed by the AYCC after January 6th of 2024. I never got the opportunity to talk to them about it.
If it's not in the record, then we can't consider it. Right.
It is on the record that they never responded to any of my accommodation requests. That is clear.
All right. Thank you. Commissioner Sanders.
Sure. Good morning, Ms. Price. Thank you very much for coming today. We appreciate your time and your participation and engagement in the process. I just want to make sure that I understand sort of not factually what you're alleging, but the basis of your legal argument. In a nutshell, if I understand it correctly, you are alleging that the respondent here had an obligation with respect to this physical space to guarantee, right, that you would never be hit by a basketball while you were, hang on a second.
Yes, sorry.
Never hit by a basketball while you were inside the facility accessing and watching your son's game. Is that the nature of your legal argument?
Not to never be hit by a basketball because it's a child's game. They generally don't get it in the hoop. The basis for my legal is that they did not participate in any interactive process to determine a reasonable accommodation. There was never any communication, and by right,
I understand that's your contention. Do you understand though that the law doesn't require that the respondent here or a respondent in general produce the request, right, that you're making specifically. What the law requires is that the respondent, here in this case, that they produce an accommodation that effectively addresses the need that you have. And so I think where I'm struggling, and perhaps where the commissioners may be struggling, is why isn't the opportunity to sit on the player's bench or sit at the timetable, which is what happened here? Why is that inadequate as a matter of law? And I just heard you say that it's not their job as a legal proposition to guarantee that you'll never be hit by a ball. That's the requirement. I see that the respondent met that requirement. You certainly have concerns that they didn't engage you in further conversation. So I'm curious, why do you believe that's required under the law?
Okay, so the options that they gave me, sitting with the team side with a bench, that is sitting adjacent with a plastic barrier to another game in motion. So that is not a safe place to be because it is actually on the court between two active games and with just a plastic barrier behind. So that would not have been any protection for me to be hit. Sitting at the timetable.
Ms. Price,
but my question though, right, we just agreed, I think, the respondent is not required under the law to guarantee that you'll never be hit by a basketball. What they're required to do is provide you with access to the facility, right?
Yes, ma'am, and they did not do that.
Okay, that's all I have.
Okay. Any other commissioner questions for Ms. Price? None. You will have about 4 minutes left when we come back to you. No, 2 minutes left. Sorry, I'm doing my math wrong. Commissioner David.
I do have a question, Ms. Price. Did they know of your condition before you got there?
No, but I did explain to them why I needed it multiple times thereafter. I did not expect a resolution to happen that game at that moment. I didn't. I went and sat where I was directed. I assumed that I would be able to discuss my need for an accommodation with Beth LaFontaine, the athletic director, as the communication was directed to us as basketball parents.
The need for an accommodation was to have some different physical place to sit, right?
The need for the accommodation was for a need to sit, not in the lane of
I think the answer is yes. Your need for an accommodation that you told them when you got there was to have a different seating arrangement than was possible then.
I'm sorry, I'm confused. I'm sorry. So the day of the occurrence, I had never had to talk to them about accommodation or to disclose my health issues.
Okay.
And again,
they had no prior notice of that from you, and you've said yes to that. Did they at the end of this day say that they could schedule the games in the other two gyms for your son?
They did, but they did not do that. They did not schedule in the other two games, the two gyms going forward.
You indicate that would be acceptable to you?
I indicated that would be acceptable if there was an area for me to sit in specifically. The concern is because people look at me and they don't see my disability. If I go up to somebody and I say, could you move because this is the safest place, they're not going to move for me. And there is not a safe place to sit. If they had given me direction and said, in gym 1, you sit here, in gym 3, you sit here, that would have been fine. There was no direction given at all.
Okay, thank you.
Thank you.
Any other commissioner questions for Ms. Price? Okay, you'll have 2 minutes when we come back to you. Attorney Scott, you have 10 minutes. Do you want to reserve any of that time?
No, I'm sure there'll be extra time. So to the extent there is, if I need to use that, I will.
Okay.
Thank you. My name is Joshua Scott. I represent the respondents in this matter. I'm not going to spend a long time here. I think the investigative report was pretty clear on this case. But as the complaint was mentioning, this case arises out of an incident on January 6, 2024, and the complainant was attending her son's community basketball game. Now, noticeably, this complaint was filed with the commission 2 days later. So to the extent we heard about wanting further discussion and communication, this is one incident, and it happened on January 6th. Within 2 days, there was a complaint filed with the commission. The fundamental issue here, from respondent's perspective, is that the complainant had access to these games at all times, including on that day. As the investigator's report clearly described, on that day, complainant was sitting on the top of the bleacher row with other individuals and was told to step down. She did so along with others. Now, there are signs there that talk about that because of liability concerns, because of safety concerns. People are not allowed to set up there. She was asked to move to a different location. She expressed her concerns about being hit by a ball. She was given a couple options, as she mentioned. Now, whether or not those options were acceptable to her, that's a different issue. But during that day, there were multiple conversations with the complainant about her concerns. Whether or not she liked the tenor of that, there were discussions. They engaged in communication. But at no time that day did the complainant request an actual accommodation. She did not say, here, if you do this, if you do X, if you let me sit over here, that would solve the issue. From the perspective of the respondents, they had provided access. They had allowed her, given her new place to sit, they thought would address the issue. And as she said herself, in a gym like that, it's very tight. There are very limited areas, if any, where you can guarantee you won't get hit by a ball. The law in this case is clear, and it's as laid out in the investigator's report, that at all time, the complainant had access to the facility. She was able to go to the games to watch them. She's seen other games. She was there that day. She stayed there. And there was no requested reasonable accommodation that would have addressed this. The first time it's even been sort of addressed in any manner is today. They had a policy. They had areas actually where individuals can sit. This wasn't a situation where there weren't areas where she could sit or where she could access. And in fact, this was the first time she'd ever even raised this. And going into this day, they didn't even know there was an issue. And though it's unfortunate as we sit here today that the complainant has had a negative experience there, she's continued to access the games. She was able to access that day. She was able to sit in a spot. And at no time did the respondents not provide their or comply with their obligations under the law. As we talked about, the law requires that that they have to provide access to individuals with disabilities. They provided that access. Whether it's access and whether she had concerns about how it's addressed, that's a different issue, but they complied with their legal requirements and obligations. I will also say, we talked about there's some addressing of accommodation requests after this, and although this is about this one day, these were in pleadings to part of the commission. These were not separate communications that occurred. The only separate email that I've seen is the one from this year where they said, yes, we will make sure to provide you with those different gyms. So as we sit here today, respondents have complied with their obligations. They followed the law, and regardless of whether the complainant disagrees with the accommodations that were provided or the access provided, does not provide for liability. Thank you.
Commissioner, questions for Attorney Scott? You'll have about 6 minutes when we come back to you. Ms. Price, you have 2 minutes and 6 seconds if there's anything else you'd like to add.
Thank you. There is. I actually wanted to show a picture of the timetable seating where I was. So this is the actual game. You can see I'm sitting right here by the timetable. You can clearly see that here, this is the game of trap. This is the game. So this singular, I'm sorry, it's hard to see. The singular bleacher seat is right here, and I was sitting right there. Now that accommodation that they gave me, I still was hit 3 times by the ball while seated here. One of which I did show via a video. The the other party stated that it was, I sounded excited on the video and I was happy to have it caught there. And that is absolutely just incorrect. Both of my children play basketball and we don't have family around here. So I do video a lot of their games and I make a reel and I send it to my family. That is why I was videoing. On that day, I asked for an accommodation after. I explained why I needed accommodations. Up until that point, as a 10-year member, I did not need any accommodations because I was not disabled. I now am, and I am still ongoing. The response that I didn't ask correctly in asking for an accommodation in the multiple times that I did ask for an accommodation, there is no legal term into how to properly ask for an accommodation. When I did ask for accommodations after this, I did include all parties, including the attorneys and anybody at the MHRC, because it's relevant to the case at hand. Again, I was made very clear on that day in how I was treated not to ask questions. So it's interesting to me that I get accosted by a person multiple times in the middle of the game against the rules set, and yet my request is the problem because I didn't ask the right way. Mr. Garrett made it very clear to me not to ask him any questions. And when spoken to and treated that way, I will not re-engage the person that's going to talk to me that way. I will put things in writing, as I stated, because I felt I was not being heard. Thank you.
Any commissioner questions for Ms. Price? Seeing none, we'll move back to Attorney Scott. You have 5 minutes and 50 seconds if there's anything you'd like to add.
No, I have nothing further. Thank you.
Any commissioner questions for Attorney Scott? All right, we've heard from the parties. Next, we'll hear from Nupur Leva, the investigator assigned to this case. Sorry.
Good morning, commissioners. I don't have anything to add. The parties have explained their cases to you as they did to me. Everything that I found to be relevant is laid out in my report as well as my reasoning. So if you have any questions, I'm happy to answer.
More questions for the investigator? Seeing none, thank you, Nupur. We have heard from the parties and the investigator. At this time, we're looking for a motion. There are 2 proposed findings.
I see one proposed.
One proposed finding. I copied, pasted something incorrectly. Let's keeping you on your toes. Everyone.
The investigator's report or recommendation as written that there are no reasonable grounds to believe that the Boys and Girls Club and YMCA of Greater Waterville at the Alphon Youth and Community Center and Peter Garrett discriminated against Kristen Price on the basis of her disability, and that the complaint should be dismissed in accordance with 5 MRS section 4612 subsection 2.
Second.
Moved and seconded. Any discussion? Okay. Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds. We thank the parties for their participation, and the commission will send a letter confirming the results of the hearing.
Thank you.
Next case is H24 334 A and B Edwards. They feel that Lady versus Tier and Griffin.
Do we want to take, this is the case where, so I'm just going to say for everybody who is party to this case, when we received the respondent's submission of disagreement by email, it was missing a couple of pages, which nobody noticed because the transition from page 1 to page 4 sort of made sense. When we received it by mail, it did include all of the pages, but at that point, nobody was looking at what had come in by mail because we assumed we had the same thing by email. I have provided the commissioners with the full submission of disagreement, but what I'm going to recommend is that we take 5 minutes so that they have an opportunity to read the whole thing, and then we'll come back and start the hearing. Does that sound good?
Okay.
Okay. So we'll mute ourselves and we will come back in 5 minutes for the hearing. Okay,
So that matter is there are multiple counts. There's a recommendation for a finding of reasonable grounds on the first count, and then recommendation for findings of no reasonable grounds thereafter. Because of the finding for reasonable grounds, I think is the more significant, and we'll hear from respondent first on that count. That sound right?
yes. Good morning, Attorney Limburger. You have 10 minutes. Do you want to reserve any of that time?
Yeah, I'll reserve a minute and a half for rebuttal.
Okay, whenever you're ready, go ahead.
Great, thank you. Good rainy morning. My name is Corey Limburger and I represent respondent Forrest Tier. We appreciate the investigators' work. We are here for two purposes. First, we agree with the investigators' recommendations of no reasonable grounds as to sex-based discrimination and retaliation theories. Second, we respectfully disagree with the recommendation of reasonable grounds as to Mr. Tier on the claim framed as sexual orientation discrimination through a hostile housing environment. Our request is straightforward. We ask the Commission to adopt the no reasonable grounds findings, and we ask the Commission to reject reasonable grounds as to Mr. Tier and instead find no reasonable grounds and dismiss. I'm going to make 2 points. First, that this case is outside the intended scope of the housing discrimination claim because it is a private neighbor easement dispute, and the Commission should be cautious, respectfully, about expanding jurisdiction under the interference provision into that space. Second, even if the Commission does reach the merits, the record does not come close to the severe or pervasive threshold required for a hostile housing environment claim. This matter arises out of a long-standing dispute over a right-of-way easement for logging access. The parties disagree about the proper width and use of the easement. This is not a landlord-tenant case. It is not a sale or rental transaction. It is not a refusal to rent or sell, and it is not a denial of housing services. Respondents do not control complainants' housing, their occupancy, or the conditions of their residence. The investigator's recommendation proceeds under the Maine Human Rights Act interference provision, which uses the words coerce, intimidate, threaten, or interfere with the exercise or enjoyment of protected rights. The Commission can decide that interference may reach some conduct outside of a traditional landlord-tenant relationship. But if the Commission does that, it should also adopt an important limiting principle. A neighbor property dispute is not automatically a housing discrimination claim. If interference is read to cover any interpersonal conflict occurring near a home, the MHRA becomes a general forum for neighbor disputes and it loses the limiting connection to housing rights that the statute and the case law require. Here, the core conflict is a property and easement dispute that escalated into animosity. That is not a reason to excuse offensive speech, but it is a reason to insist that the Commission apply the correct threshold before labeling this as a housing discrimination case. The Commission can acknowledge that certain language is unacceptable and still conclude that this record does not present meaningful coercion, intimidation, threats, or interference with housing rights as those terms are properly understood. Which leads into my second point. The investigator applies a hostile environment framework using the severe or pervasive standard and the totality of circumstances factors. Under Maine law, those factors include frequency, severity, whether the conduct is physically threatening or humiliating versus a mere offensive utterance, and whether unreasonably interferes with use and enjoyment. Maine also requires an objective and subjective component. The question is not simply whether words were offensive. The question is whether the environment is objectively abusive and severe or pervasive enough to alter the conditions of use and enjoyment of the home. At the reasonable grounds stage, the Commission is asking whether there is at least an even chance that complainants could prove those elements in court. Respectfully, on this record, there is not. The investigator identifies 3 events, 2 alleged comments, and 1 incident involving flags. Let us assume for the purposes of this decision that the investigator's recitation is accurate. Even then, the conduct is episodic, spaced out, non-threatening, and not shown to interfere with use and enjoyment in the way the severe or pervasive standard requires. The first alleged comment is in April 2023. The second is in April 2024. Those are approximately 1 year apart. The third event involving the flags is about 6 weeks after the second comment. This is not a pattern of persistent ongoing harassment. It is not frequent conduct. It is the opposite of pervasiveness. Severe or pervasive is a high bar. A small number of incidents spread across long intervals generally does not meet that bar unless the conduct is unusually severe. Second, and critically, none of the alleged statements were heard in real time. None were made in any in-person confrontation. The remarks were captured on a camera. They were not communicated directly to complainants. There's no allegation of face-to-face intimidation. There's no allegation of a threat. There's no allegation that Mr. Tier approached complainants, threatened them, or physically confronted them on the record. Those facts matter because the legal standard specifically asks whether conduct is physically threatening or humiliating and whether it actually interferes with use and enjoyment. A hostile housing environment requires more than offensive words captured by a camera when no one is present and no confrontation occurs. And the record described in the report does not identify restricted access to the property, denial of any housing service, or any material change in living conditions. Moving on to one comment in the report about motive. The investigator states that the motive is irrelevant because the language referenced protected status. Respectfully, that is not the complete legal inquiry. Even if a comment is made in evidence of animus, the commission must still determine whether the conduct meets the severe or pervasive threshold under an objective standard and whether it meaningfully interfered with housing rights. The commission can condemn the language and still conclude that under the totality of the circumstances, the conduct is not frequent, not physically threatening, not confrontational, and not shown to materially interfere with the conditions of housing. So in closing, we respectfully ask the commission to do two things. First, adopt the investigator's recommendations of no reasonable grounds as to sex-based discrimination and retaliation. And second, reject the recommendations of reasonable grounds as to Mr. Tier on the hostile housing environment claim. Under a proper application of the interference provision and the severe or pervasive standard, there's not an even chance of prevailing on these facts in a civil action. Thank you for your time and happy to answer questions.
Commissioner Sanders and then Commissioner Jetro.
Good morning, Attorney Lindberger. Thank you for being here. Curious about the epithets that your client used. Why, I understand your argument. How would you dissuade me from concluding that even absent temporality, right, there's some time interval between the conduct that we're talking about, even in the absence of sort of a physical encounter or an in-person encounter in which those epithets were used. Talk to me about why those two epithets, so significantly offensive and inappropriate, why can't we conclude on the basis of those two incidents that in fact that meets the severity standard? You noted a moment ago, right? You characterized your client's language as, offensive, right? They're objectively and subjectively highly offensive and concerning. I'm concerned about the conduct here. So tell me why the commission shouldn't conclude that use of that particular word on two occasions isn't sufficient to meet the legal standard for severity.
Yeah, that's a great question. I think the first point in talking with my client is that they simply didn't believe they were going to be heard on those cameras. They were.
Why did that matter? The complainants have knowledge of the fact that the slurs were used. So why does it matter that they didn't have real time knowledge of the same?
Well, I just believe it just goes to the fact that there was an attempt to materially change housing conditions or, threaten in that way that's required by the statute. While the language used is offensive and severely offensive, it doesn't rise to that level of severity to affect the housing. It was and there and it was not made with the attempt to interfere with housing rights in this case. They believe they were.
What was it in an effort to do then, if not to subject?
I mean, this was in the context of a very heated property easement dispute. It certainly, the comments were not meant to be kind or or respectful in any way, but it was not meant to, these were not done with the motive or the intent to get these two individuals to leave their housing. It was done out of animosity and being upset. I think one of the, if you, I'm sure you have watched the videos, and if you watch one of the clips, they're referencing damage done to the road and their inability to pass because of some of the things that were done on the easement. And one of those comments comes up in that way where there's a waving at the camera, and that comment, that word is used, that epithet is used. And there's further discussion therein in that about how it's just getting, really, really difficult to, move through, do the job that they're trying to do, the logging work. And so, it comes from a frustration. No, I'm not condoning the use of epithets, but this is the motivating factor here is not based on protected characteristics. It's coming from an anger about the ongoing situation of trying to be able to do one's job and feeling interfered with.
Is this an intent-based statute, though, Attorney Lindberger?
I believe that there is a aspect where maybe not going to the sort of a mens rea of having to find intent in that way, but I believe the motivating factor, it has to be due to an attempt to interfere with based on a protected characteristic. And in this case, that was not the reason for which these comments were made.
Commissioner Douglas?
Yeah, good morning. Good morning. So two things. First of all, this business about this being all about an easement dispute. I'm just going to be straightforward with you. I don't understand that at all. Having litigated and tried a number of easement boundary dispute type cases. So this remark comes up in the course of a trial in an easement dispute. I think the objection is, how is that possibly relevant, Your Honor? I think that objection is sustained. So I don't understand that. And if it's something else you want to tell me about your suggestion that this is not some sort of discrimination case, this is related to the easement dispute, I'm all ears.
Yeah, absolutely. I mean, again, I go back to the video clips that were provided as evidence. What we see there is not someone that is intending to threaten or interfere with somebody's housing rights. These comments are made in a manner that is out of frustration and being upset with the situation regarding the easement. I mean, it is a statement that no one would think of as respectful. That is true, but it is not. This is not the kind of thing that the respondents were leading with in their interactions with these folks. They did not meet these folks with that kind of animosity. This happened after a long-standing back and forth around boundary issues, and many different types of boundary issues. And so that is where that context is important in this case.
I understand, but the word that was used, right? I mean, listen, if this is my case, right? The way I'm going to litigate it is I'm going to say, contrary to what you just said, that word was in fact used to change somebody's housing circumstances. That word was in fact used to place people in fear, right? That there's some hateful person out there who's viewing these people differently and does have this hostile animus. Because again, you don't need to use that word, right, in order to express your views about the easement dispute. And so I think people are going to understand that. It just in terms of the even chance standard that you referenced. I think people are gonna get that. So the pride flag thing, I understand there's a dispute of fact there. I get that. But there's also a chance that a jury sees it the complainant's way. And so, I guess I'll give you an opportunity to respond to that. Specifically, my statement that this word is so offensive right? And it was so unnecessary in this context that a reasonable person, right, might assume that there was some sort of effort to make these people uncomfortable on their own property, right? Which is really what we're talking about here.
I take your point. I think that again, watching the nature in which these, in these comments were made, watching, the video clips, the cameras, there wasn't even an intent in that case. And again, I understand the comment about this not being an intent based, they heard it, but there wasn't even an intent for them to be heard in this case. They thought they were dealing with game cameras that generally don't pick up audio. There was a visual waving at the camera, and then they moved on with their work. It wasn't, in this case, there was not there was no attempt to make people feel so uncomfortable in their property. This is, I think, as as disrespectful as these comments may be, I think in this case you have someone that is not necessarily understanding the impact that their words would have. And it is not due to a motivating. They were not trying to get them to leave because they were hateful or in disagreement with the way that the complainants led their lives. This is out of frustration of an easement dispute.
All right, thank you.
Commissioner O'Brien?
Could I ask Barbara a question? And if I'm, let me just go.
You can always ask me a question.
I'll ask
I may
you.
not be able to answer.
Okay. Thank you. The allegation or the presumption that this is not a housing issue. Tell me about right-of-ways and easements. Does that include?
I can't talk about right-of-ways because I'm not a property lawyer, but I don't have to in order for you to understand how this is interfering with property rights, not in the traditional sense, but what the interference statute says is that an individual has the right to be free from discrimination in their housing. So, for example, somebody showing up and using epithets. Right. It doesn't matter that he wasn't trying to block the easement.
Okay.
It's interference because it's interfering with their right to enjoy their property free from discrimination based on their sexual orientation.
Got it. Thank you.
So the actions and the words didn't matter.
The actions and the words do matter. It doesn't matter that they weren't trying to block an easement or steal property.
And it didn't matter that they had an easement. It could have been an independent third party that had no other
that
connection.
showed up to hunt on the property, for example, and started using these epithets.
Okay, thank you.
Okay.
Just one follow-up question, Attorney Lindberger, and I can't help myself because I heard you say something in your response to Commissioner Douglas's question that I just want to really drill into and make sure I either understand it or you have an opportunity to correct it. I think what I heard you say was that the epithets that your client used was in frustration, right, over this dispute on the land that was playing out. But I wrote it down because I was surprised to hear you say this, which was, quote, "It was not out of a disagreement over the way in which the complainants live their lives," end quote. That's astonishing to me. I would submit that there's no other reason to use that particular word other than to comment upon an individual's sexual orientation. And so I want to give you an opportunity to come back on the record and address that.
Sure. I mean, that's simply my understanding from talking to the respondent is that these comments didn't come from a place of animus about how the respondents live their lives. I mean, it was not, yeah, I mean, I think, I stand by that comment, and I think that was what I meant to say there. I do
So
not.
my hope is that, your clients now understand, right, that as a subjective, right, matter and as an objective matter, a reasonable person would conclude, and in fact, the complainants subjectively concluded that comment is squarely, right, rooted in animus towards sexual orientation. And there's really no other context, right, in which that word can be reasonably understood, right, to mean. So that's my point.
Mm-hmm. Yeah, I understand what you're saying. I just, this was not, this wasn't an attempt to interfere with housing rights in this particular instance. This was, they didn't even intend to be heard on these cameras.
Commissioner David.
Does the ongoing issue over years around the use of the easement ever wind up in court, to your knowledge?
Sorry, say that again. I had a hard time.
Ongoing dispute about the easement over many years ever wind up in court?
I do not believe that it's ended up in civil court. I do not believe so.
So the situation is, if it's not about the easement, I mean, it seems to me that what Commissioner Sanders is saying is, how could it be anything but animus, to use that epithet? How can it be anything but objecting to their lifestyle?
I mean, yes, right. I mean, I think what you have, frankly, here is a case where different people react to different language, and and in a different way. And I don't think here this case, I think the respondents in this case, certainly understand how this was received, but I don't think that their intent in speaking this language was such to intimidate or make these folks move from their home. I think at the core of this issue and why we're here is because they're, again, as I've said, this is an easement issue. They're looking at the totality of the record. There was a lot of dispute going back and forth about how this road was to be used, and there was frustration about inability to use this road for the job. This was not an attempt to get these folks to move or leave or interfere with their housing.
Thank you.
Any other commissioner questions for Attorney Limburger? Seeing none, you'll have about 4 minutes when we come back to you. Mr. Edwards and Mr. Blaney, I would just ask that you pick one person to present your case, if that. What?
I will.
You don't have an attorney or another representative, do you? It's just the two of you proceeding on your own?
Correct.
Okay.
So he's for the
He's for the respondent. You have 10 minutes. You may reserve some of that time to respond to Attorney Limburger's next presentation if you'd like.
Okay, so I'll just start. We didn't actually receive the full amount.
You haven't either. I apologize. I thought that you might have received a copy in the mail.
Yeah, we checked. It's on the informed delivery in the post office. It's there today.
Oh no.
Mail forwarded. So, but regardless, we'll move forward and
I'll take that into consideration then this morning.
So yeah, what I have prepared is based on those 2 pages that I have, not the whole thing, but in any case, I'll just say the respondent is asking you to reject the investigator's reasonable grounds recommendation on the hostile housing environment claim. The submission argues that this is an easement dispute and that it is a single incident involving pride flags, which was an accident. However, the record does not contain one flag incident, it contains 3. March 13th, 2024, I submitted video from my security cameras to the sheriff's office showing Mr. Tier driving off the traveled roadway onto the grass where I had placed pride flags to run them over. I had put them there just a few days earlier, and this was the first time that he had seen them, and The first time he saw them, he chose to run them over. On May 30th of 2024, as the investigator report states, Mr. Tier again drove over a pride flag placed on the side of the easement, caught on video. He also entered our garage uninvited. He refused to leave when we told him to leave many times. And he called us girly men many times, repeatedly. He tried to coerce us into fighting him by asking us to step outside of the garage and, quote, settle this like real men. On October 8th of 2024, again, video shows Mr. Tier using his tractor to destroy posts with pride flags and banners. This was the day after his attorney acknowledged receipt of my MHRC complaint documents. The sheriff's office issued a criminal mischief summons for this. Mr. Tier claims that visibility of the pride flags was an issue. However, those pride flags had been there since June. They are rainbows. They're very bright. They're easy to see. And so they had been there for 3 months until the day after he received those documents and then chose to run them over. So they were there for 3 months before the grass grew up around them. He knew they were there. His submission discusses only the third incident where he ran over the flags and offers that it was a mowing visibility issue. But they do not account for the first 2 incidents, and they don't account for the pattern. Additionally, the flag incidents don't exist in a vacuum. The record contains video recordings of Mr. Tier directing homophobic slurs at us. On April 29th, 2023, he was recorded calling us faggots while driving past our cameras. On April 19th, 2024, with Mr. Griffin present, Mr. Tier looked directly into a security camera, waved at it, and said, "Hi, faggots." On May 30th, 2024, Mr. Tier again called us girly men to our faces in our own garage well outside the easement. The record also contains security camera recording in which Mr. Tier and his associates spent roughly 3 hours parked on our property directly in front of the cameras while making homophobic remarks about us, discussed shooting our property with an M16 rifle, and talked about sabotaging their own equipment and blaming it on us for insurance money. During this conversation, Mr. Tier agreed with a companion's homophobic characterizations of us and speculated that we were, quote, bullied as children. They also discussed ways to make our lives miserable, and they acted on those discussions. In another incident, our dog was caught in a coyote trap that was placed directly on our property line where we walked our dog, which the responding game warden told us was the, quote, best marked property he had seen in his 35 years. Recordings of the conversation with the game warden reveal that Mr. Griffin directed the trapper to place the coyote trap in that exact location, knowing that it was where our property line was and it was where we walked our dog. With roughly 500 acres available to him to place a coyote trap, I find it extremely difficult to believe any reasonable person would think to place a trap directly on our property line unless there is malicious intent. So this is the context the respondent's submission strips away. When you combine repeated homophobic slurs, recorded threats, and 3 separate incidents of destroying pride symbols over several months, that is not accidental. This is a pattern. It's a pattern of conduct directed at us because of our sexual orientation. This is within MHRC's jurisdiction. The respondent argues this falls outside housing discrimination jurisdiction, but the MHRA's interference provision applies to any person who coerces, intimidates, threatens, or interferes with someone's exercise of housing rights because of protected class status. It is not limited to landlords. An easement dispute may be the backdrop, but it does not explain why Mr. Tier used the word faggots or why pride symbols become targets. Those are markers of conduct motivated by sexual orientation, which is exactly what this statute covers. The hostile environment standard requires evaluating the totality of the circumstances, frequency, severity, whether the conduct is physically threatening or humiliating, and whether it interferes with the use and enjoyment of the home. The Commission's own published guidance describes exactly this kind of situation, including a series of incidents involving slurs and vandalism targeting sexual orientation. The respondent cites an employment case for the proposition that offensive language alone does not cross the threshold. We agree this is not about language alone. It is about language combined with repeated, targeted destruction of symbols of our identity, combined with recorded threats of violence, combined with a broader campaign of intimidation. And the ultimate measure of interference with housing enjoyment is this: we were forced to sell our home and leave. That is not an abstract legal question. My husband and I bought that home in May of 2021 and officially moved in February of 2022. By April of 2024, the harassment had made it impossible to live there safely. There was a period when I would hide in the woods with my dog whenever I heard a vehicle approaching, and I would not come back to the house until Mr. Tier had left the area. I also was forced to relocate my electrical business, losing the customer base I had built in the community. We should not have had to give up our home because of who we are. So considering the totality of the record, there are certainly reasonable grounds to believe this conduct created an objectively hostile housing environment and it interfered with our right to enjoy our home without discrimination. Thank you.
Thank you. Commissioner David.
Are you Mr. Edwards?
Yes.
Yes, I just wanted to make sure I've got the name right. Could you say that the harassment, that the conduct has led you to be forced to sell your home?
Correct.
When did you do that?
So after the after the May 30th incident, we made the decision to list the house and we listed it in June of 2024.
Was it May 30th, 2024? Was that the incident?
Yes.
Okay. I think I just did not hear the word you were saying about the placement of something on the property. Was it a trap or something to do with hunting?
Coyote trap. Yes.
A what?
A coyote trap.
A coyote trap. I'm sorry. It's the first time I've understood what you were saying. You say there were 3 incidents about pride flags and one of them involved destruction of destruction of a flag on your lawn.
Yes.
Is that correct?
Yeah, I think there
Is
were
that in the record?
5 flags total that were on the lawn, where there are pictures in the record that show he drove off the road onto the lawn, ran over a row of flags.
Okay, thank you.
And just, I know there have been a couple of questions about what is in the record. I'm in communication with Investigator Leva, and so far nothing has been said that is not in the
Well,
record.
that's informative. Thank you.
Okay.
Well, she's sitting there quietly.
Yes. Nuber usually lets me know if I forget. Any other commissioner questions for the complainant? Commissioner O'Brien.
It's not a question, I just say good presentation. Thank you. You hear me?
Yes, thank you.
Thank you. Okay.
I do have one more. You're only pushing the first agreeing that there are reasonable grounds for the discrimination, but not the second, third, and fourth. Is that correct?
Admittedly, I'm not hopeful with anything that's gone on, and I'm just looking to take anything as a win.
They did not submit anything. That's what we're asking. They did not submit a disagreement.
They did not submit a disagreement to those 2, 3, and 4. Okay, thank you.
Any further commissioner questions for the complainants? You'll have a little over 2 minutes left when we come back to you. Attorney Limburger, you have 4 minutes and 9 seconds if there's anything else you'd like to add.
Just that the trap that was mentioned was found by the game warden to be on the respondent's property. They weren't on the complainant's property when they were doing this. And I believe it was alleged that it was Mr. Griffin that was put the trap there, not Mr. Tier. Just to be clear about that. I'm not sure if that was stated clearly. And then yeah, I don't believe I have anything further at this point.
Further commissioner questions for Attorney Limburger? Seeing none, Mr. Edwards, you have 2 minutes and 9 seconds if there's anything else you'd like to add. You don't have to use it if you feel you've said everything you want to say, that's fine.
Yeah, I think so. Thank you.
Thank you.
Any additional questions for Mr. Edwards or Mr. Blaney? Okay. Seeing none, at this time we've heard from the parties, and next we'll hear from Nuber Leba, the investigator assigned to this case.
Good morning again, commissioners. I don't have anything to add like I didn't in the previous case, but I'm happy to take any questions if you have them.
Any commissioner questions for, yes? Commissioner.
Yeah, just curious, Investigator Leva, the allegations and sort of the factual posture that Mr. Edwards described in his presentation included a number of additional facts that were not contained in the investigation report. I'm just curious if you could walk the commissioners through how you evaluated those allegations, how you investigated them, and then to the extent they don't appear in the report, why you made that choice.
Sure. So the facts that I've included in the report were facts that I could absolutely corroborate that actually occurred, whether I had video footage or actual statements from the parties on what and what was not said. There were pictures of flags being run over and things like that, but there wasn't actual video to show me who had run it over, when it had been run over. So I chose to stick to what I could absolutely corroborate in this case. I felt like that was a better sort of foundational understanding for this case, and so that's what I decided to put in my report.
Nuper, is looking at those videos, are those epithets, in your opinion, directed to the plaintiffs? In other words, they're saying to the camera the offensive epithet to them?
To me, it appeared that they were said directly to them. I didn't understand, or I didn't see another reason to wave at a camera, even if you assumed it was a game camera, to wave at it and use an epithet of that nature if you weren't intending for it to be heard by the complainant.
He's not using the epithet to the logger.
Right.
Okay, that's my question. Yeah, thank you.
Mm-hmm.
Any other commissioner questions for the investigator? Seeing none, thank you, Nuper. We've heard from the parties and the investigator. At this time, we are looking for a motion. There are 4 proposed findings.
I'd like to take the first one only. So I move to adopt the first recommendation in the investigator's report. There are reasonable grounds to believe that Forrest Tier discriminated against Brian Edwards and Martin Blaney on the basis of their sexual orientation and gender identity, hostile housing environment. Conciliation of the claim should be attempted in accordance with 5 MHRC 4612, subsection 3.
Second. Moved and seconded. Any discussion? David?
Yeah, initially I was concerned about the pervasive prong, and also concerned about the effect on the housing, and the complainant's presentation is extremely convincing on both of those issues, that this is pervasive and it is affecting their housing, and has persuaded me that's unlawful discrimination.
Yeah, I mean, just to follow up on that, when you use words like that, unnecessary, well, there's never a good reason to use words like that. I mean, there's certainly going to be an even chance at trial that a fact finder is going to conclude that these words were used with the intent, not that you need intent, but, and did in fact have the effect. We all heard complainant's presentation of interfering with their enjoyment and use of their property, such that they moved. I mean, that's pretty powerful stuff. So I'll be voting yes.
Commissioner O'Brien?
Just to say, there are many cases that are difficult. This is not one of them to me.
I mean, the conduct alleged here is egregious and it's disturbing. And certainly with respect to the first finding, as Commissioner O'Brien noted, this is the easiest case we've heard in a long time with respect to that finding. There's no question about it. So I'll leave my next set of comments for discussion about findings 2, 3, and 4. I agree, complainant's presentation here today, incredibly disturbing. I know it was emotional to get through. It would have been for me as well. And I'm grateful that you're here today to do just what you did. So thank you for that. The additional facts that you've alleged, tying back to Commissioner Douglas's remarks, and understanding investigator Leva's decision to not include them here, in favor of relying on facts she could corroborate, right? Those allegations make for, I think, at least an even chance at trial to prevail. So at any rate, that's, it's no surprise how I feel about the next 3 allegations. Potentially, we'll work through them when we get to them, but certainly with respect to finding number 1, my vote is to vote to affirm.
Any further discussion? Okay. So the motion is to find reasonable grounds on the first finding. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. So then we need a motion for findings 2, 3, and 4.
You're up. You're up.
Thank you. On finding number 2, I move to find that there are reasonable grounds to believe that Dale Griffin discriminated against Ryan Edwards and Martin Blaney on the basis of their sexual orientation or gender identity, and this claim should be dismissed in accordance, conciliated. Yes, thank you for, I caught myself. Thank you for applying the word. And the claim should be conciliated, and conciliation of the claim should be attempted in accordance with 5 MRS section 4612 subsection 3.
Second.
Moved and seconded. Discussion.
I'm just curious to hear from one of you, what are the facts you're relying on?
This is the logger, correct?
Yes, the employee.
Yeah, the employee.
Contractor,
Yeah, I think I heard.
Hang on a second.
Yeah.
I believe that attorney, and I apologize. Am I Pelegi or Pelegi?
My family pronounces it Pelegi.
Pelegi, okay. I believe that attorney Pelegi represents Mr. Griffin. Is that, am I correct? Yes. And
Well, then we
since
haven't heard.
we haven't heard from him because there was no agreement to that claim.
I guess I was wondering, right, if there's been no disagreement filed, we can still. And if we can, it does seem fair to let Attorney Pelleggi speak.
I
right?
think,
Yeah.
I don't, and normally I would tell you that if that hasn't been challenged, it hasn't been challenged, but y'all have the right, if you decide that there is a finding that you don't believe is correct, it's ultimately your decision. So I think that you can flip it. I do not think you should flip it without hearing from Attorney Pelleggi.
Great.
Yes.
So
let's, because there's a motion on the table, let's withdraw the motion, please, and ask if Mr. Pelleggi would like to address us.
Thank you.
wonderful. Thank you, Attorney Pelleggi. And very specifically, I know you've, have thoughts and observations to offer, but I'm specifically interested in as well is if you can tease out for us the conduct, right, as alleged against Mr. Tier and the conduct alleged with respect to your client.
Yes, first of all, let me say, excuse me, let me say procedurally,
that this complaint against Mr. Griffin would have been handled by the commission's consent agenda because there was no statement of disagreement submitted by the complainants. I didn't have to be here today, and I'm here out of an abundance of caution. And so I disagree that the commissioners are entitled or have legal authority to act on the complaint and to take an approach different from that recommended by the investigator because the complainants didn't disagree. I'm happy to discuss facts, but I respectfully reject the notion that because I was here and because you got to listen to the tier evidence that somehow changes the Griffin status from consent agenda to something else.
And if you want to address the mayor, I am pulling up the rule to make sure to check the language because this is a new, this doesn't usually happen. So I want to make sure that I've got the language right.
And while Attorney Archer's doing that, certainly with respect to addressing the merits, that would be incredibly helpful, at least for.
Certainly. So first of all, Mr. Griffin is the owner of a logging company. He is one of many drivers, truck drivers, equipment operators, and other individuals who used the right-of-way over the Martin and Blaney property to access the tier property where there was a fairly large logging operation going on. Unlike the tier allegations, there was never, and let me just say the complainants have advocated thoroughly and well for themselves and did so for the investigator. And there's a wealth of material and information that they submitted, none of which contained or suggested that Mr. Griffin made any remarks whatsoever regarding Mr. Edwards and Mr. Blaney's sexual orientation, gender identity, sexual preferences, or any protected class whatsoever. I agree with the investigators' findings that there were a series of conflicts in terms of using the right-of-way that some of which are summarized very broadly in a footnote in the investigator's report, but not laid out in any great detail. We did a resolution conference. The parties all testified. I will represent that Mr. Griffin's name barely came up in that testimony by the plaintiffs. Mr. Griffin utilized the road. He testified about the facts that when a gate was put up by the complainants, they would lock the gate immediately behind the logging equipment, making it very difficult and dangerous for equipment coming back out to the road. That there were air horns from Mr. Edwards or Mr. Blaney that were blared at truck drivers. Truck drivers revved engines. All of this is consistent in my experience, and I've tried boundary and easement cases now. I'm going on something like 37 years. It's entirely consistent with the way people behave when they're having property disputes. Mr. Griffin was a logging contractor. He just needed to use the road to make a living. The dispute over the road impeded his ability to make a living. He's an employee, or he's an independent contractor who worked for Mr. Tier to log Mr. Tier's property. He's not an employee of Mr. Tier. He doesn't get imputed any intent or language or comments that Mr. Tier might have made. Mr. Griffin, the evidence was unequivocal that he was simply trying to do a job, and there was a dispute over his ability to use a road to do the job. And that is not, I don't want to talk, you didn't ask me to talk about legal standards, but respectfully, that supports the investigator's factual determination that while there was conflict, it was not at all related to a protected class.
Barbara, were you? Oh, sorry. The rule says nothing useful. I'm looking at the statute. Whoever wrote that rule needs to. What are we? Oh, yes. Whether or not they even have the right to consider.
Okay.
I'd like to reopen the presentation from the complainants. I believe that I asked them as my last question whether they contested those last three findings. I'd like to give them an opportunity to speak to Mr. Griffin's behavior if they wish to.
I disagree with that jurisdictionally. I
Yeah,
object.
just
Yeah, everybody
Take five.
Take 5 or a minute, let Barbara look at the law and come back with an answer.
sorry, I thought it was in the.
I also think we have the authority to do what Commissioner Sanders is moving for. I think we have the authority to find that there is.
We take a 5-minute.
Could we please?
Sure. We'll take a 5-minute break and we'll come back with an answer.
Why?
Yeah. Thanks. All right, my turn. I apologize. I believe that Attorney Pelleggi is correct. I was remembering something in the rules that is not there. Whether or not it always won't be there is a different thing. But for now, what we have is a rule that says that only folks who have objected get to present, and that people who agree with, who did not submit a written disagreement can appear and speak in order to rebut the disagreement. So I think that while we don't split cases and put some things on the consent agenda and other parts for hearing, that's just not a procedure that we follow. I do think that the no reasonable grounds findings where they weren't challenged are off the table right now. And again, I apologize. Thank you for making me look, Attorney Pelleggi, because I was misremembering the rule, even though I wrote it.
All right.
So that's it with this.
So this motion has been withdrawn.
Yeah, the motion's been withdrawn. We still need a motion to adopt those findings.
Oh, okay.
Yeah, the 2, 3, and 4.
Yes.
So moved.
Second.
Seconded by Ed. Okay. Moved and seconded. Any discussion? Okay. Being none, if you vote yes, you are in agreement. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are split findings as they are written in the report, which means that we will send a letter to the parties and council regarding next steps. So for, I believe I'm getting this right, for Attorney Limburger and the complainants, that will be conciliation. For Attorney Pelleggi, I believe you will receive a letter stating that the case against your client is closed. And that could go out in the next couple of days.
Forthwith.
Thank you all for listening to me.
All right, thank you, and thank you for your patience as we work through. I do not think I have ever seen a case in that posture.
No, it was weird.
So, now we know that we've got to amend the rule again. Sometimes we learn on the fly.
Thank you all for your time.
Your lunch is on its way. Sorry?
Oh my gosh, yes. A miracle has happened. A miracle, some of you.
Great. Thank you so much. You are welcome to stay on if you'd like to watch the rest of the case, or go about your day if you'd like to not be on Zoom for another 3 hours.
Thank you.
Thank you.
Thanks. Do you guys want to grab your lunch and then we'll call the next case?
Sure.
Okay.
Yes.
Let's do this and
Shouldn't have had that
Say,
scintillating
I did it
discussion.
for you. I did it all. So
Yes, you did. Barbara has to rewrite the rule.
I mean, there are other things that it needs anyway, so.
Yeah.
It was coming. I'll just add this to the list.
What do you think? Remind you of these laid bag. That looked like a bag.
Like here at all on Zoom.
You told me that you got to.
Okay.
Caitlin McDonald.
Yeah, let me, because I have them in a row at the top, I'm being very.
Big whip.
Or maybe she's watching the live.
Oh, okay.
No, that's fine. That's fine. I just want to make sure I don't miss her if she. If for some reason she wanted.
I think I have.
Check.
Chicken Caesar.
I think that's the Caesar. Oh, that's mine. Well, we have. It's a change over here.
What healthy lunch?
Same breakfast. We're just getting, not the other break. I don't have to do it right now. Okay.
You have another one?
Yeah. Like.
Mayo on side. Mayo on side.
Colin might have gotten a question about Mayo and just asked for it on the side if he didn't have an answer from whoever ordered the sandwich. It might be yours.
I know.
did everybody get your?
We didn't get one.
So I guess it's a hot.
You got a steak bomb, right, Ed?
Yeah, is that this?
That's it? And
On
then
a
you
rack.
got two things.
And you got two things.
Yeah,
You got two things?
that looks like a steak bomb. Yeah, but they're little.
It's a rack.
You know, I got a turkey Italian, and this is a steak bomb. Is that what you want? Yeah.
Right.
Who got chili?
I did. But they're both small things.
So right here, pick your lunch.
Got it.
I mean, is that what
This is the chili, yeah.
with that bag with the mayo on the side?
Mayo on
That's
the
yours?
side?
Is it just a bag of mayo?
Giant bag of mayo.
Listen,
I want that anyway.
Any limitations? I never do.
I'm gonna use a comment on my email.
Food shaming is not a protected class, yeah.
I just want to know how much mayo you have on the side and if you're going to use all of it.
I think it's just new.
That's
A lot of mayo.
Well, if anybody
It's
needs
not
mayonnaise.
I'm just saying it looked heavy.
All right,
Did you look in the bag? What is it in the bag?
just mayonnaise.
A lot of
Just it.
mayonnaise.
Okay. So we get to the next case.
All right, the next case for hearing is Caitlin McDonald versus Michael Curran, H250366. It's a housing case. There is a split recommendation on the three allegations. The first is no reasonable grounds on disability and accommodations. The second is a recommendation that we find reasonable grounds on conditions in regards to housing. And the third, that we find reasonable grounds regarding the service animal. So we'll take the reasonable grounds as the more significant recommendation in terms of commission action, and therefore we will hear from respondents presenting first. So
Attorney Pattersall, you have 10 minutes. Do you want to reserve any of that time?
Yeah, half of that, please. Thank you.
Whenever you're ready, go ahead.
Okay, thank you. Good afternoon, commissioners. We are here requesting that the commissioners affirm the finding of the investigator that there's no reasonable grounds to believe there's discrimination for denial of a reasonable accommodation. We feel that.
Can you be a little louder, sir, or closer to your microphone?
Yeah, but is this better? Sorry.
Yeah.
Okay, sorry about that. We're asking that the finding of the investigator be confirmed, that there's no reasonable grounds to believe there's discrimination on the basis of denying a reasonable accommodation in this case. We disagree with the findings that there was discrimination with regard to the service animal, and we disagree with that simply based on the definition that's in the statute in Title V, which I'd like to read. That statute says an assistance animal is an animal that has been determined necessary for an individual with a physical or mental disability to mitigate the effects of a physical or mental disability by, and then it's among other people, physician's associate. In this case, we do have a letter from a nurse practitioner in this case, but there's nothing in that letter that talks about necessity, let alone that there's a disability. And the reason the wording of the statute is important is it's not up to me to determine whether an animal is necessary. It's not up to Ms. McDonald or Mr. Curran or even the commissioners. It's up to the medical provider to make that determination. And we simply don't have that determination in this case. So I would submit to the commissioners that we don't have statutorily compliant definition of an assistance animal. At most, we have what a lot of us might agree is that a cat helps emotionally. And I will go on the record saying I've got 3 cats and they help me. I like them. But I have nothing more than what this letter in the file says about the necessity. Second, with regard to the medical authorization, I believe the report says that Mr. Curran didn't have an explanation for why he asked for that medical authorization to be signed. In this case, Ms. McDonald notified Mr. Curran before she applied for housing with him that she had been arrested previously, had been evicted previously because she has a Excuse me, I just lost my speaker. My apologies, because she has bipolar disorder. And she made that very clear to Mr. Curran that she would like an opportunity to stay there. Mr. Curran offered that he had previously had tenants with bipolar disorder and explained that he had had one tenant go on a manic episode that was a very difficult situation to resolve. And the reason that he wanted an authorization was simply out of a compassion for Ms. McDonald to help her rather than to set a high bar for her tenancy. She was afraid that if something happened and he had no place to go to inform about the condition, that he might have the same situation unfold as did his previous tenant. So we're requesting that the commission not find reasonable grounds to believe there's discrimination with regard to the pet deposit or with the authorization, the medical authorization that was signed by Ms. McDonald.
Commissioner questions for Attorney Patterson? Right. Hearing none, you'll have about 6 minutes when we come back to you. Please, Spalding. Do you want to reserve any of your time?
3 minutes.
Whenever you're ready.
Good afternoon, Commissioners. On the issue of the assistance animal, the investigator quoted the entire support letter that was provided by Ms. McDonald's medical professional that describes the emotional support that she gets from her assistant's cat. The bond between Caitlin and Charlie has brought a noticeable improvement in her mental health, significantly reducing her feelings of loneliness and easing depressive symptoms. These types of disability verification letters in assistance animals cases are routinely accepted as sufficient evidence that there's a nexus between the assistance animal and the person's disabilities. And I would just to affirm the investigators' finding on the issue of disability by charging or discrimination by charging a $500 deposit for the assistance animal. On the issue of the medical release, again, I can't find or think of a more clear-cut situation where a person has a different term and condition on their tenancy because of their protected status. He only requires tenants who have disclosed a disability to provide a medical release so that the landlord can discuss confidential medical information with their medical provider. And that's direct evidence of discrimination. Although the investigator does do a burden shifting analysis here, I don't think it's necessary. It's an on-off switch. Tenants who are either not disabled or haven't happened to disclose their disability would not have been required to sign a medical release. And I would just request again that that be affirmed on the reasonable grounds issue for the medical release. On the no reasonable grounds regarding the assistance animal, the refusal to grant a reasonable accommodation. The first thing I'd like to point out is a more of a legal argument on the standard that was applied. There's a 6-part, prima facie elements, six elements needed for the prima facie case. And although I don't take issue with most of it, it's this issue of the meaning, the number 5, meaning it is both efficacious and proportional to the cost to implement it. There's a citation there to 2 cases from the First Circuit and 1 from the Seventh Circuit. The Seventh Circuit case does use that language, efficacious and proportional, but the 2 First Circuit cases do not. And I would suggest that using that language comes dangerously close to improperly shifting the burden of the undue hardship that is normally the respondent's burden onto the complainant. What the First Circuit cases are much, the language that they adopt is that the complainant only need to show that there's a plausible, that the request is reasonable on its face or plausible. The United States Airways versus Barnett decision says that the plaintiff need only show that the method of accommodation is reasonable in the run of cases. or ordinarily in the run of cases. Now, the reasonable accommodation requests made here were essentially some sort of opening salvo in what is sometimes called a stay and behave type agreement. That it's quite routine in cases of FED cases where the tenant is being evicted for a cause related to conduct at the property, when there's a nexus between that conduct and the person's disability, that the parties engage in an interactive process to reach some sort of what we sometimes call behave and stay agreement. Now, the exact terms of a behave and stay can vary by case to case. Some are a little bit more tenant friendly and have more flexibility on the part of the tenant, and some are a little bit more landlord friendly in the sense that they're stricter, but it's not a cessation of the eviction case, which is what is suggested by a portion of the analysis. It's that the case be continued. If there's future transgressions against the lease, the landlord can put on their case then and bring up the allegations that initially caused the notice to quit to be issued and to put on evidence of the subsequent transgression. And usually what the tenant is expected to do is, demonstrate that, but usually when that request is made, there's an interactive process where the parties reach an accommodation that would allow the tenant to maintain their housing, but with the expectation that the landlord can still enforce the terms of the lease if there's a future transgression. And in this case, the landlord preemptively short-circuited the interactive process. He expressly refused after the first written reasonable accommodation request. The 2 second reasonable accommodation requests were never responded to. The case marched forward to hearing on August 20th, 2025. And I would like to, on the issue of how this reasonable accommodation standard was analyzed here, I just take issues with some of the suggestions made in the investigator's report. The investigator's report seems to suggest that there's no evidence that anything in the future would be different had the landlord granted this accommodation, but it is part of the record. And on page 9 of the investigator's notes that when Ms. McDonald was asked what's going to be different, she talked about how she's now on mood stabilizers. This was not something that she had previously been on before. And often pharmacological intervention is quite effective and usually, a very persuasive evidence that the tenant is taking the issue seriously and has taken efforts to address the behavior that resulted in the initial notice to quit. There is a suggestion here that the landlord gets some sort of credit on his on the reasonableness argument because of her eviction at the prior tenancy. I'm not aware of any case where a landlord gets to say, hey, I did what I needed to do because I acted reasonably, or this isn't reasonable because you were evicted from a prior tenancy for your disability. And in fact, if the tenant who is applying for housing is initially denied because of prior eviction, and they're able to show that the prior eviction,
Your 7 minutes.
okay, I'll take 1 more minute, was related to a disability, it would be disability discrimination for the current landlord to say, oh, I'm not going to rent to you because you were evicted for a disability related reason at your prior housing. So I don't think that they should get any credit here for what happened at the prior eviction case or the prior tenancy. And because I am over my time, is there any time?
And Commissioner question. Looks like we've got a couple.
Nice try.
Commissioner Douglas.
Good afternoon. Yeah, I've been sitting here all morning. Of course, you have to go right after we get our lunch. We appreciate you being here. So on the denial of a reasonable accommodation issue, I'm just not sure. I take your point about the Seventh Circuit case. The First Circuit case is a different standard. You're sort of arguing that the wrong standard was used. How does that make a difference in this case? I mean, allegations here, $11,500 of property damage, the other tenant filing a criminal complaint, et cetera, et cetera. mean, just to be honest with you, the last couple minutes of your presentation, you kind of lost me.
Okay.
So tell me, if we apply the standard that you want, how does that make a difference in terms of the findings of this case? I don't see how it does, but I'm willing to be educated.
My point about the improper shifting of the burden is something that is inefficient or something that is disproportional. Sounds a heck of a lot like something that would be an undue hardship that the landlord would have to prove. And so by relying on this efficacious and this proportionality argument, I don't think that it's properly on the plaintiff to show at this stage. But what the proper standard is that the complainant's request only be, as the Barrett's decision says, the method of accommodation that is reasonable in the run of cases. My point is that the behave and stay type agreement that I'm describing is reasonable, or frequently the method used in all of eviction cases involving conduct for harm. Evictions based on conduct, that when there's a nexus between the conduct and the disability. So I believe we have, under that standard, making a request for a reasonable accommodation that somehow we enter into some sort of behave and stay type agreement is at least enough to shift the burden to them, at which point the interactive process should have been triggered. And he could say, you know what, based on the actual out-of-pocket costs that I had to repair, I can't do a payment plan with you. But we had no interactive process. We did have a quote that was done for $11,000, but the receipts for actual out-of-pocket expenses were for about $400. And the lease agreement actually contemplated that the tenant, if there was alleged damage in the unit, that the tenant could pay for it. So the request that the eviction be, put on hold, or that they essentially have this probationary agreement while she repays for the actual out-of-pocket damages, is routinely used in these types of cases. And the landlord did not engage in any interactive process, just refused the first one and didn't respond at all to the second two. And my concern is that if just because the landlord thinks subjectively in their mind that the request is
crazy,
unreasonable, that this process still requires an interactive process. With the other First Circuit case, that the LePage versus the Bakeries case, where it talked about an example of a method, an accommodation request that would be clearly unreasonable on its face, was if an employee says, hey, why don't you move your operations to a warmer client? Like in that type of situation, you wouldn't really expect the employee to engage, that wouldn't shift the burden to the employer to engage in the interactive process. But the request made here is a routinely made request in these types of eviction cases where the tenant has transgressed the terms of the lease, maybe is on the hook for something, and says, hey, I'm on mood stabilizers now, my conduct's gonna be different going forward, I'd like to pay you for the damage that I did. And that was not engaged with in any way whatsoever. And I think there's an even chance that we have a case for failure to reasonably accommodate.
I understand the argument. Thank you.
Yes, I'm similarly having a challenge with this particular argument. We've heard this argument in the past. We've rejected it. I don't know that I've heard anything new that would change the outcome. You reference, it's common to engage in what you call a behave and stay agreement. First of all, thank you for that. I've never heard that expression before, so I appreciate that. The behave and stay agreement. I guess I'm curious though. It would seem to me, unless you can educate me otherwise as a matter of law, that whether or not a landlord does that with these facts is entirely discretionary on the landlord, right? So in this case, we've got an individual who, per footnote 2, damaged the premises, threatened the neighbor, violated her lease, created risk to health and safety of other tenants, and then she also stopped paying rent when she lost her housing voucher. So it's not clear to me, setting aside disability, if we just focus on the conduct, right, regardless of disability, why isn't it just the landlord's discretion under those circumstances to do what any landlord do, maybe, which is to initiate an FED action.
Yeah, I'm not taking issue with the FED action itself, but and if the tenant had no disability, then they would have no defense to the allegations that you're discussing here. But the issue is when that conduct, that antisocial conduct, has a nexus with the person's disability, that becomes, the statute provides for a reasonable accommodation defense based on failure to offer reasonable accommodation. And the nearly every case involving a tenant's eviction for their conduct involves a situation where they were relatively stable mental health wise for some period of time. They become destabilized. They engage in some transgression of the lease. Then they get connected with their medical provider or mood stabilizers in this case and bring their conduct back within the terms of so.
What if it was an assault? What if she, so, right, we understand there was criminal conduct here, but what if she engaged in an aggravated assault or, committed, a serious criminal offense against a person? Under those circumstances, is your argument the same, that the landlord, with an assault, aggravated assault, attempted murder, let's just play out the hypothetical here, also under those circumstances required to engage in a disability accommodation discussion if that conduct, right, criminal conduct, is tied to an underlying disability? Is that what you're telling us?
So the federal statute does talk about the direct threat standard, and in a sense that's an exemption, which seems to suggest that if the direct threat standard is met, that the landlord is excused from all future interactive process. There is at least one federal case that says no, you can only decide if the direct threat standard exists if after going through the interactive process, after exploring the ability of mitigating efforts to address the issue have taken place. And then if at the end of that interactive process, you come to the conclusion it's not reasonable because the person has not addressed their substance abuse issues, the person is not engaged with treatment, perhaps the person has, the type of, sometimes these cases involve pedophilia, that type of stuff. Like there are, I agree with you, some extreme versions of the facts where the landlord can say, hey, it's inconceivable to me that any reasonable accommodation would protect my property and my other tenants. But I still maintain that you have to engage in the interactive process in those situations. And especially in the case it's still here where there is, I'm not suggesting that this fact pattern is as extreme as what I'm suggesting there, but and I think it's dangerous to leave that up to the landlord's subjective belief. I think this request is crazy, and I don't even want to engage in the interactive process. So I'm bailing and I'm marching forward to eviction regardless of your request.
Do you and your colleagues at Country who litigated that argument in Maine?
Yeah. I mean, I guess, do you mean like go on a trial or? Yeah, I can't say I do as well as I wanted to, but.
Okay. So that I appreciate.
I hate to be silly, but this isn't in the record.
I love everybody doing a raising hands back in front of us. I understand this is an interesting legal question, but I'd like to focus on the case we've got.
I'm taking liberties because I'm curious. I'm really curious about this argument, and I'd love to hear more to the extent you obtain a favorable decision.
I think Commissioner Sanders is trying to get at the state of the law in Maine, not necessarily the facts of the record.
It was just and I almost never say this about Megan, but an inartful question in that you appeared to be asking about how Pine Tree practices law.
Absolutely not. But I would say it's an argument we've heard in this venue before. I'm curious about it, and so I wanted to ask you about the status of that argument in this jurisdiction.
Very good.
I'm gonna get a little spicy here.
I have not had lunch yet. We all have eaten.
We haven't all eaten.
I said you all, I was looking at them.
I want to ask you about the service animal. Is it the unlawful discrimination because it's in this particular case and not for all tenants?
Okay, so Ms. McDonald made a request for an assistance animal.
Right.
And provided a disability verification letter that there was a nexus between the disability and the use in the animal.
Right.
And
Would you not charge, if you charged all your tenants a security deposit for an animal, could you not charge?
so my understanding of the law is that if it's just a pet, a good old fashioned pet, they can charge for that. But the instant that the tenant is able to demonstrate that the animal is not a pet, but an assistance animal, you can't charge for an assistance animal like a deposit. So I know sometimes when we're being relaxed, we might say pet and assistance animal interchangeably, but they're very different concepts. And yeah, while he could charge for pets, he can't charge for an assistance animal.
Yeah. Any other commissioner questions for Attorney Spalding? Got 2 minutes left, so you'll have opportunity to talk about that. Sorry. Okay, Attorney Pedersol, let me just set up my timer. You have 6 minutes and 10 seconds.
Okay, thank you. So before she applied for the tenancy, Ms. McDonald said, she wrote, since release from jail in January of 2024, I am stable and now have a support system in place. So something like this will not happen again. Mr. Curran decided to give her the chance to rent from him. I disagree with Attorney Spalding saying he gets credit for that. That's not a credit. He decided that I'll let her stay here. And that's why he asked for medical authorization, and that's a separate issue you can decide. But shortly after she moved in, she did cause thousands of dollars of damage to this property. She did threaten other people. She did get arrested. This assistance cat was left behind with no food and water for 2 weeks until he was found. There was a problem here. Mr. Curran was represented by counsel. Ms. McDonald was represented by counsel. There were discussions back and forth. I think you'll see that the requests for the accommodations are directed to myself and my associate Bill Campbell, and they were not ignored. The decision was made that this request, essentially to go back to the status quo ante that led to the problem, was not reasonable. It was an unreasonable request. So yes, Mr. Curran has an obligation to give a reasonable accommodation, but he does not have an obligation to give unreasonable accommodations after his property has been not destroyed, but severely damaged. His other tenants who he has duties to have been threatened, their privacy invaded. There were risks posed by the smoking that was going on in the apartment. He did not just subjectively think this was unreasonable, it was objectively unreasonable. After this conduct occurred, Lewiston Housing Authority terminated the tenant's voucher. They would not make any further payments. Based on the HUD regulations, the lease between Ms. McDonald and Mr. Curran automatically terminated. We went to court on a tenancy at will eviction. The affirmative defense of a denial of a reasonable accommodation was raised by Attorney Spalding. It was litigated and the judge disagreed with him. He found that there is no duty to allow the destruction and risk to health on the part of a landlord, that it was reasonable that he could go forward, and judgment was entered for the landlord in the case, and it is on appeal. I'm not saying that Judge Robinson's judgment is binding on the commission, but it was raised and rejected by co-branch of government in this case. On the assistance animal, the statute says what it says. I didn't write the statute. It just says that the medical provider must determine that it's necessary. It doesn't say that the medical provider must determine that it helps. And that's just a matter of statutory interpretation I don't need to ask any more about. So I'm happy to answer any questions that the commissioners have.
Commissioner Douglas.
Yes, Attorney Pedersol, good afternoon. So I just wanted to, on the service animal, your argument, because I'm looking at the letter, February 5 letter in footnote 1. Your argument is that it just doesn't have that required statutory language. That's what that's what you're saying. Because it clearly says that it's helpful to her, right? It helps her cope with her disability. So
yes, Commissioner Douglas, I agree with you. I mean, it doesn't come out and say, and I'm sure that these medical providers aren't looking at the statute and copying down the language. But when I read that, it does say this animal seems to help her. It gives her a sense of comfort, but it doesn't talk about even that she has a disability, let alone that this cat is necessary to mitigate the effects of the disability. I'm just going by what the statute says, and that's a matter of the commissioner's interpretation of the statute. I'm not going to die on that hill, so to speak, but that's just the argument.
Thank you.
You're welcome.
Any other commissioner questions for responding staff? Seeing none. Attorney Spalding, you have 2 minutes if there's anything else you'd like to add.
Yes, I would just encourage the commissioners to not rely on the decision made by the district court judge. That matter is on appeal. It's not a final judgment. Again, if you go back to the elements and what it requires for the burden shifting, the request made here is the usual or typical type of request made in these types of cases. I believe we've shifted the burden properly to the defendant to at least engage in the interactive process, which was not done here. That what you'll see in the complaint is that after the first request, they expressly denied that one. And then for the 2 subsequent requests, they just never responded to either one of those. And there was a complainant earlier who couldn't prove his case because the respondent pointed out that the complaint is short-circuited preemptively, the interactive process. And I can't see how this is any different here. They made a reasonable accommodation request and the landlord did not engage in it at all. I recognize that there is a quote for $11,500 that looks pretty bad, I suppose, but it's a quote. What we have for actual out-of-pocket expenses for the landlord are about $400. Some of the issues in the quote, like say the stove being damaged, the stove, that didn't actually exist in the unit. The stove wasn't damaged. Some of the aspects of the quote for like trash cleanup, the client, Ms. McDonald ultimately did that herself. So there's a variety of things in the quote that were never, actually incurred by the respondent. So I just don't agree that they should be able to rely on that to say that they found that it was unreasonable.
Just respectfully say, I'm sorry, just real quick, that the difference between that earlier case and this case is that in that case, we had somebody that was withdrawn from a nursing program. And in this case, we have criminal activity, property destruction, et cetera, et cetera. I mean, I think they're different cases. So if you want to respond to that, it's fine. But
all I'll say is in these eviction cases where the tenant is being evicted for conduct, it's almost always some sort of antisocial type behavior that most of us at first blush would not, encourage a tenant or advise them to engage in, I suppose. But what matters is there a nexus between the conduct and the disability? And here we have that in spades. She has a bipolar condition, had a mental health manic episode. And I think the nexus part, they don't dispute the nexus part, but the nexus between the disability and the conduct in this case is so strong that, and like I said, again, I believe we've done everything necessary to shift the burden to require the interactive process. The respondent came back and said, no, I went out of pocket on this $8,000 and you can only repay me over 12 months and I can't accept 12 months. That's not reasonable for me. Maybe, but they didn't do any of that. They just said, nope, or didn't respond. And that's where I believe we have at least an even chance that this is a failure to accommodate.
I'm quite confused. What's the difference between 1 and 2? The conditions of housing or the reasonable accommodation? What do you want? What do you want the commission to do in terms of these findings?
Commissioner, to affirm the 2 reasonable ground standards related to the medical release and the assistance animal, charging for the assistance animal.
Okay, in terms of 2, you want us to affirm that there's unlawful discrimination in terms of the terms and conditions of housing, right?
Mm-hmm.
Why?
To the terms and conditions, I believe that's the one about the medical release. Am I right on that? That's the medical release one where a term of her condition, of her tenancy was that she provide a medical release so that, that other tenants don't do.
And you want us to reverse the recommendation and find that there are reasonable grounds in terms of failure to accommodate a disability.
Yes, Your Honor. Yes.
We didn't make it today.
I built it in the morning.
Any further questions for Attorney Spalding? All right, thank you. We've heard from the parties, and next we'll hear from Angela Morse, the investigator assigned to the case.
Hello, I'm Angela Morse. I'm the investigator that was assigned to this case. I don't think I have anything to add, but I'm certainly willing to answer any questions.
Yeah, so good afternoon. In your view, right, why does the respondent not have a duty to engage in the interactive process here? As Attorney Spalding has argued.
And I wouldn't even go so far as to say that there was a failure to engage in that process. Certainly, the complainant didn't get the outcome they wanted, but this was also through counsel. So this, these negotiations, and there were 3 basically requests for pretty much the same thing. So, and again, even if that prima facie case had been established, I think that the respondent could support their contention that granting that accommodation request would be unreasonable.
Thank you for that. Do you want to briefly talk about your finding that this was a service animal?
Yes, I think it's pretty clear. And in the letter, it says that the cat's presence plays a crucial role. I don't have the exact language, but crucial role in helping Caitlin manage her stress and anxiety. Also, the reason that this letter was even supplied in the first place was to establish why an assistance animal was needed, because if there wasn't a disability, this wouldn't have been provided, this note. And there had been discussions about the disability before this note was provided. So I think this is pretty clear cut.
Thank you.
Any further questions for Investigator Morse? Seeing none, we've heard from the parties and the investigator. At this time, we are looking for a motion. There are 3 proposed findings. Together or split them up?
I move that we take them together and we adopt the recommendations from the investigator as written in the report. 1, there are no reasonable grounds to believe that Michael Curran discriminated against Caitlin McDonald on the basis of disability. Denying a reasonable accommodation, this claim should be dismissed in accordance with 5 MRS 4612 subsection 3. 2, there are reasonable grounds to believe that Michael Curran discriminated against Caitlin McDonald on the basis of disability and the terms and conditions of housing. 3, there are reasonable grounds to believe that Michael Curran discriminated against Caitlin McDonald based on disability by imposing unlawful conditions on the use of an assistance animal. And finally, conciliation of these claims should be attempted in accordance with 5 MRS section 4612 subsection 3.
I'll second that.
Moved and seconded. Any discussion? Okay, seeing none. The motion is to find no reasonable grounds on the first recommended finding and reasonable grounds on the next 2. If you're in agreement, you will vote yes. Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Okay. So the findings are as they are written in the report. We appreciate everybody's participation, and the parties will receive a letter as to next steps.
The penultimate case is housing case H250379, Tory versus Advest Housing. The recommendation is for a finding of a no reasonable ground. Therefore, we'll hear from complainant.
In 1 second, everybody else.
Can I get a napkin? I can't eat this.
Oh,
Yeah, I tried and can we take 5? I asked you
Yeah,
to go to the
okay.
bathroom anyway.
We'll be in recess.
All right.
Okay, we're back. All right. So Ms. Tori, we're gonna start with your case. You have 10 minutes. You want to save any of that time to respond to the respondent's presentation? And you are muted right now. If you could unmute yourself.
Yes, I'll reserve 1.5 minutes, please.
Whenever you're ready, go ahead.
Okay, good afternoon, commissioners. Thank you for this time. I am here because I have a disagreement, or I believe some of the things that I disagree with Alex Brindley's investigative report. The first disagreement I have is on page 2, paragraph 1. That's incorrect information. Complainant requested 2 reasonable accommodations, RAs, to have an air conditioner in her unit and to close the public hallway window when the heat index was high. I submitted only 1 RA, not 2. I did not request an air conditioner from my unit. I already had an air conditioner, and it had already been installed by Avesta staff. I asked for air conditioning so that the $51 would be waived. In addition, all eligible Avesta residents are granted the waiver for the $51 payment for electricity for the use of the air conditioner. This was not a special consideration granted just to me. After about a month had passed and I hadn't heard anything from Avesta regarding whether or not my RA for the window had been approved or denied, I spoke with Lindsay, who was the resident services coordinator, in person. She told me that a letter had been sent to me on 7/23/2024. I said I hadn't received it. She looked in and she pulled it out of my file and gave me a copy. The letter was sent by Christine Martin. It was dated 7/23/24. I never received the letter in the mail, as it was reflected in my informed delivery information. It had only been filed. I had not been notified. Why was my request for air conditioning granted, but the denial to have the window closed on high index days not done until October 8th? Why did it take 3 months for the second part of the RA to be denied? With full knowledge of my disabilities, including supporting documentation from my medical providers, which was provided to Avesta directly by my providers, not from me, Avesta did not take into consideration that July, August, and September were the months with the highest level of heat index days, the most difficult months of the season for me to cope with my breathing difficulties. By 10/8/2024, the RA was no longer needed for that year. On page 2, paragraph 2, at no time was I told to clean my premises of my apartment. I was told that cleaning the toilet bowl of the mold would take care of the mold issue. I was provided with bleach tablets for the toilet bowl. I've used bleach tablets in my toilet since 10/18/24. The mold comes back over and over and over. Regarding the air quality test, I was not provided a copy of the air quality test until after I had requested it. No one ever contacted me to let me know whether they thought the level of mold in my apartment was acceptable or not. I called and left a message for Sam Muggaby, the property manager. She called me back and left me a message on my machine stating that there is no indication of mold in your apartment. How can I address it when somebody can't read a report and plainly see that there is all this mold in my apartment? Regarding the extreme heat in my unit, which did in fact exacerbate my disabilities, the respondent investigated the problem and promptly addressed the issue. However, there is a vast difference between addressing an issue and fixing the problem. I was never told what they were going to be doing to try to fix any of the heat-related issues, even after submitting numerous work orders. They acknowledged that I had an issue, but they didn't do anything to fix it. The item in the investigator's report that I find to be most problematic is found at the bottom of page 2, footnote number 3. Complainant did not allege that her work orders to address the mold and heat were requests for reasonable accommodation, nor did she allege that respondent failed to address her work orders because of her disabilities. Because the complainant did not make these claims, they were not analyzed in this report. At no time during the time I have been a resident at Avesta Properties, which is 12 years, did anyone tell me that for issues that might have causation directly related to my disabilities, I was required to submit an RA to have them addressed instead of a work order? That includes the issues of the mold and extreme heat in my apartment. That being said, how can those claims not be analyzed in this report? I have told staff repeatedly over the 3-year period that I have lived in my apartment that there are issues with heat and mold. I was never told that I had to submit an RA for these issues, which would include documentation from my providers. So I submitted work orders. I don't believe it was or is my responsibility to document my disabilities every time I submit a work order or an RA, and I strongly object to the work orders about the mold and the heat not being analyzed in this report. I believe that by not analyzing these claims in this report, I was indeed discriminated against. In a letter from Christine Martin, who's a 504 coordinator on 10/8/20.
Ms. Story, please don't use the names of people who are not named in the complaint. You can use their titles, so property manager.
Even
rental
though
assistant.
even though she was a witness?
Yes.
Okay.
Their
In a
names
letter
are
in the letter from the residential services coordinator dated 10/8, she stated, I quote, "Management proposes that it gives you permission to break your lease without penalty. While you are not required to do so, in this alternative way, you can seek housing that better suits your disability needs. This tells me that Avesta does not intend to meet my disability needs, whether it be by work order or by RA." The senior property manager, I guess, regional property manager, sent me a letter on 10/31 addressing the mold in my toilet. She stated, quote, "If there is something additional that is causing concern, please contact the property manager, Sam Mugabe, and she will enter a work order."
Please don't use that person's name.
I didn't hear you.
I said, please don't use that person's name.
Sorry. This doesn't let me tell me to do a reasonable accommodation, does it? Tells me to do a work order. High heat, mold, bathroom fan that continues to blow down instead of taking air up. No matter how many work orders or RAs I submit, as of this date today, 3/16/26, I still have mold in my apartment, on my food, not just in my toilet. It is very hot in my apartment, and my bathroom fan is still malfunctioning. Nothing has changed, and I have been living in this condition for 3 years. On the legal analysis of it, page 3, paragraph 3, quote, "thus making it untimely for the commission's purposes."
That is 8 minutes and 30 seconds. You can keep going. I'm just gonna keep your time going.
Okay. How was it determined that it was untimely? Did the commission make an assumption that it was untimely because the denial didn't take place until October and the time frame was beyond when high heat index days were considered? If that is the assumption that was made by the commission, then that assumption is not taken into consideration that, as I stated previously, the first part of my 7/23/24 RA was granted, but the second part wasn't denied until 10/8/24. I submit that Avesta's staff's denial was untimely. They took 3 months to make the denial. If it had been taken place at the same time as the acceptance for the first part, then it would have been timely, and I could have appealed Avesta's denial. That's all I have for right now. I'll entertain questions gladly.
Any commissioner questions for Ms. Torrey? Seeing none, you'll have about 30 seconds left when we come back to you. Attorney Drury, you have 10 minutes. Do you want to reserve any of your time?
No, I don't think it's,
Right.
I'm not gonna take the full 10 minutes, so that's fine.
Okay, whenever you're ready.
Well, good afternoon, commissioners. Thank you very much for your time. My name is Chris Drury. I am counsel for the respondent. We agree with the investigator's finding that there's no probable cause that discrimination took place. Just a couple of things. With respect to the request for the air conditioning, whether it was a request for air conditioner or a request to have Avesta Housing pay for the electricity, the fact is Avesta Housing did grant that request and is paying for the electricity for the air conditioning. With respect to the request for basically it was control over the window in the hallway on the second floor. And Avesta Housing never told Ms. Torrey that she could not open or close the window. It simply said that it could not grant Ms. Torrey exclusive control over the window, meaning if she felt it was too hot and she wanted to close the window on a particular day, she could certainly do that. If her neighbor complained and her neighbor wanted to open the window, then her neighbor could open the window. And that's something that would have to be resolved between the tenants. But basically, the request was that Ms. Torrey be allowed to control whether the window was open or closed. And Avesta Housing thought that that was unreasonable in terms of a request for accommodation. Additionally, whether Avesta Housing denied that request in July or October of 2024, the complaint was filed in October 10th of 2025. So the denial of that request for accommodation, the complaint regarding that denial was untimely and it was beyond the 300 days. So the investigator properly concluded that that request was barred by the statute of limitations. And then with respect to the request for accommodation concerning the heat in her apartment, in Ms. Torrey's apartment and the mold issue, when Ms. Torrey submitted work orders or she made complaints about mold, Avesta Housing responded. They did hire a company. The company performed testing and determined that the levels of mold in the apartment were very acceptable. Ms. Torrey did not, and the investigator properly found, she did not submit any request for accommodations regarding the excessive heat or the mold in her apartment. And so therefore, Avesta Housing didn't engage in any sort of interactive process to determine if it could accommodate a request because it didn't receive a request. So the investigator properly found that the complaints regarding the mold issue and the excessive heat in the apartment were not considered as part of the report. And then finally, with respect to the request to be transferred to another floor within the building, Ms. Torrey is on a wait list. Avesta Housing did accommodate that request. Ms. Torrey also requested to be transferred to a different building, and Avesta Housing said it could not simply transfer her to the other building, but did say that she could apply for transfer to the building, which I understand Ms. Torrey did. So as was noted in the investigative report, that during the investigative conference, Ms. Torrey acknowledged that Avesta Housing had approved, or sorry, that Avesta Housing had approved all of her requests for reasonable accommodation. So basically, there's no request for accommodation that were not addressed by Avesta Housing. And that's it. If the commission has any questions.
Questions for Attorney Drury? Seeing none, Ms. Torrey, you have 37 seconds left. If there's anything else you'd like to add.
Okay, in those 37 seconds, as I said, yes, they addressed any of the RAs, but they did not fix the problem. The work orders are for the heat and the mold and the toilet and all of that. And yes, they addressed that, but they did not fix it. Just having an air mold quality test does not fix the problem. I still have mold. The bleach tablets didn't fix the problem. I still have mold. There needs to be a culture sample done for aspergillus and for penicillium. Those are the two molds that are most.
Tori.
Thank you.
Thank you. Commissioner, questions for Ms. Tori? Seeing none, thank you very much. Attorney Drury, you have about 6 minutes left. If there's anything else you'd like to add.
No, actually, I think, well, just one thing. I think I misspoke. In the investigative report, it was Ms. Tori acknowledged that the respondent had addressed all of her requests for a reasonable accommodation, not approved. I think I misspoke and said approved. But the point is that any request for accommodation that Ms. Tori had submitted, Avesta Housing addressed that request.
Okay. Any commissioner questions for Attorney Drury? Commissioner Douglas.
Yeah, just one question, and it's probably attributable to my lunch coma, and I apologize for that. But the open window issue, can you? I'm guessing you probably addressed that in your initial presentation, and like I said,
Are you asking me?
No.
I'm asking.
Oh, okay. All right.
Could you just briefly address that? What happened with that request?
Sure. So there's Ms. Tori's apartment is on the second floor of the building, and there's a window at the end of the hallway. And Ms. Tori was requesting to be able to keep the window closed, I guess, during days where there was a high heat index. And Avesta Housing thought it was not appropriate to allow a tenant to have control over whether a window was opened or closed. So Avesta Housing denied the request to allow Ms. Tori to have exclusive control over the window. But Avesta Housing did tell Ms. Tori that if she felt it was a high heat index day and she wanted to keep the window closed, she could close the window. It just couldn't prevent other tenants from opening the window if they decided to.
And that decision was based in substantial part, I'm guessing, on your duty to other tenants as well.
That's correct. That's correct. And also, it's unclear exactly what a high heat index day is. It wasn't tied to anything. So it was just sort of arbitrary that Ms. Tori could decide when a day was a particular high heat index versus, if there was something on days where the temperature was over 90 degrees, let's say, or the humidity was a certain level. That I think would have been a little bit more objective in terms of making that determination. But simply to say on high heat index days, it really gave her exclusive control over the window.
Right, and on that point, it's undisputed, right, that the complainant had air conditioning in her unit, and you folks at some point paid for the electricity for that.
That's correct.
Okay, all right, thank you.
Commissioner O'Brien.
Just to pick up on that, you ended up paying for it. It's in the record. Are all the other tenants, is it paid for?
I'm not sure if that's accurate. I know the other tenants can have air conditioning in their apartments. I don't know if all of the other tenants, if the air conditioning is being paid for by Avesta Housing.
So, okay, so you can't say then, or can you, that there was a lapse? What?
No, I'm sorry, Ms. Tori. At this point, your opportunity to present is done.
That there was a lapse between, that she had to endure paying it for a while, whereas others would not have to. You can't say that. Or can you?
I believe that the investigator is telling me that other tenants getting a, sorry, is your question about other tenants getting, I may be a little lost.
We're all lost.
Anyway, Alex is saying that other tenants getting AC is not in the record.
Okay, all right, then my.
And again, to be clear, this issue about the air conditioning, the request for accommodation was raised by Ms. Tori in July of 2024. And she filed her complaint in October of 2025. So any complaint about that request for accommodation is untimely.
Okay, any further commissioner questions for Attorney Drury? All right, seeing none, we've heard from the parties, and next we will hear from Alex Brindley, the investigator assigned to this case.
Hello, everyone. My name is Alex Brindley. I was the investigator assigned, as Kit just said. I don't believe I have anything additional that I think that I need to add at this time, but as always, I'm open to questions.
Commissioner questions for the investigator? Seeing none, thank you, Alex.
Thanks.
We've heard from the parties and the investigator. At this time, we're looking for a motion. There is one proposed finding.
I'll move that we find that no reasonable grounds to believe that the respondent unlawfully discriminated against the complainant, and the matter should be dismissed.
Second.
Been seconded. Any discussion? Seeing none. The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. So the findings are no reasonable grounds. The commission thanks the parties for their participation, and we will send.
Thank you.
Confirming the results of the.
0392, 292 A and B. If I'm mispronouncing the name, Obadiah Management. The recommendation is for a finding of no reasonable grounds, and therefore we'll hear from the complainant to present first.
Good afternoon, Mr. Obadi. I apologize. I think maybe it would be tell us how to pronounce your last name, and then we will not we will not make
just call me Obi. Okay, easier for you.
Okay.
Yeah.
Mr. Obi, you have 10 minutes. Do you want to reserve any of that time?
Yes, if I have to. I'm here today. First off, good afternoon, everybody. And
Mr. Obi, our computer that was broadcasting shut down, so I have you now on my computer. I just want to make sure that we haven't lost the live feed. Can you hear me okay?
yeah, I can hear you.
Okay. Okay,
And
great. Mr. Obi,
I can hear anybody. Just making sure I can not hear anybody. I don't know. Everybody can hear me.
appeared. Okay. Obi, can you hear me?
You breaking up, but I can hear you.
Great. Okay. Is it any better? No, my connection is unstable. Let me see. How about, can you hear me now?
I can hear you, but I think your screen is frozen.
I turned my audio off because that sometimes helps with audio problems. I'm connected to the internet with my
You were breaking up.
okay. One moment to everybody. Mhm. Are you connected to the internet,
Yes,
Jane?
I appear to be.
Okay. Shall we try this again? I appear to be frozen. Mr. Obi and Attorney Ware, can you hear me?
Yep.
Yep, we can hear you now.
Better now?
It is.
Great. Can you, okay. I don't know what that was. The entire building's internet just went down, but it appears to be back on now. If everybody can hear me, then I think we'll go ahead and let's start over. Mr. Obi, you have 10 minutes. Would you like to reserve any of your time to respond to the respondent's presentation?
Yes, if I have to.
Jane, we can't hear him. Okay, awesome.
And I have my glasses on because I have a disability. So,
It's still talking. It
you
doesn't.
know. Should I start?
1 minute. Thought we were ready or not?
So, oh,
Seriously.
nope, hold on.
Wrong output.
Nope, because my computer's muted and my computer's using the TV. We should be okay.
Okay. Third time's a charm. Did you want to reserve any of your time? I think so. You can all hear me, right?
Yes.
Okay.
there we
And
go.
there, we can hear you. Okay. My goodness, I apologize. I don't know what is happening right now, but I think we're good now. Did you want to reserve any of your time to respond to Attorney Ware's presentation?
Yes.
Okay, how much time would you like to save?
I don't know.
Shall I give you 8 minutes to start and save you 2?
So am I starting with 8?
You have 10 minutes total. People usually reserve 2 or 3
Okay.
minutes.
So I will start with 5 and reserve the rest 5.
Okay. Whenever you're ready, go ahead.
So the complainant, which is I disagree with the investigator's reports because the fact that she relied upon to support the finding lacks foundation and improperly adopts the respondent's version of the story of the events over my own account of what evidentially happened. And based on the undisputed fact, I believe that the commissioner should find a reasonable ground to conclude that I was racially profiled by the respondent. And the fact behind this reasoning is that Bellport staff falsely accused me for dumping trash near the building dumpster area after viewing a video that showed a black man and a white woman dumping trash. And this dumpster is a public dumpster that everybody uses. Even people who doesn't live in our apartment use this same dumpster. And they impose a financial penalty against me without conducting a proper investigation. And based on their based on the video that they saw of a black man. And when I tried to dispute this issue, the airport staff who I spoke with, who was also the person who accused me for dumping the trash, stated that the video that he made that as assumption on was a video of a black man and a white woman, and therefore he concluded that it was me. So when I tried to tell him that it was not me, he kept saying that it was me, and I told him that that is a racial profiling, and he laughed and said I was being ridiculous. And I went and found this video, and I sent him the video telling him, hey, this is not me, and this is not my wife's vehicle. And I didn't get no response. So I made 2 other calls to the, I believe their manager and the owner of Bellport Management. And later on that day received an email saying that the charges will be disputed because his boss told him to dispute that, not because I was not the person in the video. And that is how, and they ended up changing that story, saying that they made that assumption based on the vehicle at the scene that they saw on the video. And the undisputed fact is I have 2 other tenants. We have 2 other tenants in this building who owns exactly the same vehicle, dark Subaru, that was seen at the scene, but they didn't they did not investigate those tenants. And those tenants are white tenants, and they are not black. So I believe that they racially profiled me by seeing a black person in the video and automatically saying that it was me who dumped the trash, even after trying to dispute the situation that I was not the person who dumped the trash. And that is how I filed a claim against them.
Any commissioner questions for Mr. Opie? Commissioner Douglas.
Yes. Good afternoon, Master Jedi. I can see your screen name there, buddy. Yeah, so Jedi to Jedi, I hope you won't mind answering a couple of questions. So listen, in order for us to find in your favor, right, what we need to determine is that there's some racial component to all of this. Now, I just heard you say that, well, the respondent says that you were identified based on the make and model of the vehicle at the dumpster, right? It's a certain color, it's a certain make and model. You say that there are other people, at least 2 other tenants with basically the same type car, and they're white, and you're a person of color, so that's evidence of racial animus, shall we say. So I get that. Other than that, what other evidence is there to your mind that this had something to do with race and not just a building trying to manage the property?
So prior to this case, I think 2 months before this happened, I have had issue with the same Bellport staff who accused me for dumping the trash. This was a case about sink situation where they charged me, and I tried to call them and dispute this situation. And I asked for his supervisor. He said he's the boss. Like, I'm not talking to anybody. And also, there's a situation in between then, before this happened, that my heat was not working, and you know how cold it is here in Maine. And I tried to call the staff, and I asked them, hey, can somebody come work on this heat? That my heat is not working, and it is freezing in my apartment. And they told me that they were going to call me back that same day to figure out the situation, and nobody gave me a call. And I believe that if they honestly think that they made that accusation based on the vehicle, my wife is not the only person who owns a Subaru vehicle. They should have contacted the rest of the proper investigation to figure out who dumped the trash, but they just said I was the person who dumped the trash solely based on the video. And even when I tried to dispute it, telling them I was not the person, they didn't believe me. and he called me ridiculous and said I was being, he laughed at me and said I was being ridiculous for even mentioning that.
Right, but at some point, they did say that they made a mistake and took the charge off of your bill. And I'm kind of wondering, because the report's a little vague about that. How did that happen?
I mean, so them disputing the charges after 3 attempts does not eliminate the fact that I was being racially profiled against. You know,
Hold on a second. No, I understand that. I'm just trying to get at how was that charge removed? Did somebody say we've made a mistake? Did somebody say this is somebody else doing this? And what was represented to you as in terms of why this charge was removed?
So the email and the evidence that I produced during this situation is, it was stated on the email that these charges was only disputed because his boss told him to. That was the reason that they gave, not because I was not the person who dumped the trash. It's because his boss told him to dispute the charges. That's the reason they gave me, and it was printed in an email.
Okay. Did anybody tell you that they had determined that it was not you?
No.
But they removed the charge.
They did remove the charges.
Okay. All right. Thank you.
Good afternoon. The manager, I'm going to read a line from this report. The manager attested that he had never met the complainant and did not know his race prior to the conversation. The management software does not contain information about the race, the tenant's race. Could you speak to that, please?
You asking me? Sorry?
Yeah, yes.
I mean, I don't think that makes sense because I've been to their office several times and they know everybody who, first time I came to Tori's apartment, I met somebody from their office. And the reason, if they actually think that, to me, I don't know, the way I see it, I don't know, I know everybody sees it differently. To me, I see it, the way I see it is, it's kind of impossible for them to say that they based they accused me for dumping the trash over the vehicle, because I'm not the only one who have the same vehicle. Even the vehicle that my wife has is not identical to the one that was seen at the scene. So that's why I'm saying, like, it's 2 other tenants. If they actually based that assumption of a vehicle, they would have contacted the other tenants, but they didn't.
Okay.
And my wife is blonde.
Okay.
Okay.
Are you, so you're disputing, bottom line, you're disputing the fact that they didn't know your race? Is that what?
They didn't know my race. It's impossible that they didn't know my race.
All right, okay, thank you.
Any other commissioner questions for Mr. Obi? Okay. You'll have about 6.5 minutes left when we come back to you. Attorney Ware, Attorney Pucci, who is presenting for respondents.
I'm happy to start. I'm happy to reserve some time to Jim if he'd like some. I don't think I'll have too long. Commissioners, good afternoon. Thank you for
A second,
taking
I
the
just want to
time.
make, can I just clarify, given what we went through a couple of cases ago, do you both represent the respondents or do you represent separate parties?
Separate parties. I represent Bellport Management.
Okay, and is there a substantial difference in your in your positions here, or like, do we need to hear from both respondents as whoever also
Why are
jumped
there
in?
2 proposed funding?
I believe,
I didn't see it being discussed.
no.
I was looking for that.
So this is, and I'm looking at the wrong pause. So this is the management company and.
There's just one finding, but it says and or.
Yes.
So they're both contained in the same
Yeah.
finding.
Okay.
So perhaps I could be heard quickly on that. To the extent that it requires animus by the respondent, there is a possible difference. Other than that, no, that we're the same.
Okay. Are you comfortable with Attorney Ware making the presentation?
I just have 30 seconds to speak on my client's behalf.
And And I won't have, and I don't think my presentation will take that long, absent questions from the commissioners.
Okay, great. Then yes, I'll reserve a couple of minutes for Attorney Pucci and Attorney Ware. Why don't I start you with 7? Have a little leeway.
Great, thank you very much. Again, as I mentioned a moment ago, commissioners, thank you very much for hearing this matter. My name is Matthew Ware. I represent Respondent Bellport Management. I don't have too much to add to the investigator's report. I thought it was well-reasoned and well-articulated. I do just want to follow up on a couple of questions that the commissioners had for the complainant just a moment ago. There's been some discussion regarding whether or not the individual from Bellport who issued the charge, the $150 charge, was aware of the claimant's race. We had submitted an affidavit, and attached to the affidavit was a printout of the information that would have been available to that individual when he was making that initial determination as to which unit to add the charge to. That's Exhibit A to that affidavit. He attested he'd never met the claimant, wasn't aware of his race. And as you can clearly see, the first line item on the exhibit to the affidavit is an indication regarding a darkish gray-black Subaru. And there are other Subarus apparently owned by other tenants in that building, but that particular vehicle is the only one that has that particular description, dark gray-black. And so beyond that, I don't have anything to add to the investigator's report. I'd be happy to field any questions the commissioners had. Absent any questions, we'd ask that the commission accept the investigator's report and issue a finding of no probable cause for discrimination.
Commissioner David and then Commissioner Douglas.
Attorney Ware, I just want to be clear, that person that assessed the charge does not work in the office. The complainant says that he's been in the office many times, and of course they know that he's a person of color. Are you saying that the person that made the assessment is in some other building, some other place, doesn't know who the tenants are?
So I'm not saying he doesn't work in that particular office. Candidly, the record's not exactly clear as to where that office is situated. What I am saying is that the record very clearly establishes is that individual who assessed the charge has attested under oath that he's never met the claimant, simply because.
Right, okay. Thank you.
Attorney Pucci.
Thank you, Jim Cloutier.
I'm sorry. Commissioner Douglas, Attorney Douglas.
Yeah.
I'm losing
I'm
my
using
mind.
the etiology of that, if you like, but aside from that.
No, that I did.
It's your turn, Your Honor. I just want to get to the bottom of this.
I really.
Hang on. No, Commissioner Douglas had a question for Attorney Ware, and then we'll move on to you.
Sorry, Jim. So, just following up on this whole dark grayish black Subaru. What I'm putting together from what's been said here is that there's a database, right, with only one dark grayish black Subaru listed. But then what complainant is saying is that there are other tenants with a similar car, regardless of whether or not it appears in the database. And I just wanted you to address that.
Yeah, and that's true. The database, and again, it's Exhibit A to a declaration or an affidavit that was submitted, so it should be in the record. The database does indicate there are other Subarus, but those Subarus are detailed as being gray. There's only one, and it's number 1 registered to the claimant and his wife's unit. There's only one that indicates a dark gray black Subaru. And based on the testimony of the Issues and Resolutions Conference and also the affidavit from the individual who issued the charge, that's how they interpreted the color on the video. And so that's what they went with. And sure, it may not have been the most detail-oriented investigation, but I don't think the record establishes that it had anything to do with the claimant's race.
Right. And if you know, why was the complainant refunded? Like, why was this charge removed from his bill?
Yeah, great question. And so he called up. There were a couple of conversations on the day of October 15th, and he called up and initially had a conversation with the individual who had issued the charge. The conversation eventually got a bit heated, and the claimant, I understand, hung up. He called back and spoke with person who, I'm trying not to use the names, of course, the person who issued the charge supervisor. He disputed it in essence, And I think this is in the record, I believe it came out at the Issues and Resolutions Conference. It is the policy of my client that if there's a dispute about these charges, they remove it. And that's what happened here. The claimant disputed it. My client removed the charge the same day.
Okay. All right, thank you.
Any other commissioner questions for Attorney Ware? Okay. Attorney Clucci, I'll start you with 3 minutes.
Thank you very much. I hope not to use all of that time. My client comes to this issue fairly late in the proceedings. We did attend the conference. My client was out of the United States during actually several parts of the proceedings, including today. The principals of my client, which is a man named Chen and his wife, whose name is Ruiz, constitute the entire management of CR Ventures. And they own this building, and they are the ones who hired Bellport to manage it, and that was not a recent event. So the only thing that I really know very much about is what I gleaned from attending the conference to resolve this. I was struck at the time that Obi had really become quite animated about the fact that the management company must have known that he was a black man, and and the Subarus were all the same. So this was a very racially charged sequence of events. The testimony didn't really support that very well because, for instance, he thought that he was the one that provided the video to the management company. In fact, they already had it. That's how the whole thing began to develop in the first place, because that's how they knew it was a dark gray Subaru vehicle. And there was plenty of evidence that there were other Subarus that were gray in the area at the time. My only meager contribution to the process was I did a little research on what the characteristics of a racial profiling are and were. The best outline that I found was in the foreign country of Canada. The province of Ottawa has a very energetic, detailed discussion of that. I think that the tenor of that discussion is reflected in the report that you have before you. So, of course, I support that. That's all I have. I'll be glad to answer any questions you have.
Any commissioner questions for Attorney Clucci? Okay. Mr. Obi, you have 6 minutes and 38 seconds. If there's anything else you would like to add.
Yeah, attorney say something about Canada, and to my knowledge, we are in Maine, not in Canada. And I don't know where the Canadian description of what racial discrimination has to do with this situation. And the other thing I have to dispute is that he mentioned that I was the one who had the video first. That was not the problem. That was not the issue. The issue is that after the respondent told me that there is a video of a black man and a white woman dumping trash, I have to go get that video myself, review it. And I sent the video back to him stating that, hey, this is not me. And yet it was not disputed. And this exhibit that they produced, which has the list of vehicles and colors of vehicles of the tenants. This was created on January 12th, 2026, which was after the issue has already. So this could be like created anytime, and it probably was created before after this situation happened in order to paint that I have a gray dark Subaru. And that is a false statement, because this tenant vehicle this is a dark gray Subaru, which is not owned by me or my wife. This is owned by a tenant. And this is another dark gray Subaru, which is owned by a tenant. Not me, not my wife. And this is my wife's vehicle. My wife's vehicle is not even a dark Subaru. It is a very light gray Subaru, not darker than, and it does not look like anything in the video. So what I'm trying to say is that if the decision was made based on Subaru, they would have contacted the other tenants who has dark gray Subaru, that their vehicle looks more exactly like the video of the people who dumped the trash, but they didn't do any of that. It's not a coincidence that I am a black person and my wife is blonde, and the people who was depicted in the video is a white woman who has a blonde hair and a black man. So this document that they provided does not mean anything. It was created on January after the incident happened. So that is not an evidence that they made the decision based on dark gray Subaru.
Okay, I just want to clarify something that I think you just said. You saw the video of you, of you and your wife, correct? And you're saying, and you're disputing the fact that it was you?
No.
Not the car. Okay, all right.
So I didn't know the video existed till the respondent told me that the reason that they say it was me is they saw a video of a black man and a white woman dumping the trash. And so I went downstairs because we have a commercial business downstairs that own the camera, that CCTV that records the whole building apartment. So I went to get that video myself to confirm if I was in the video, because I just woke up and somebody's telling me that they saw me in the video. It was a little bit confusing. So when I went and saw the video, it was nothing. It was not me. It was not my wife. It was not my wife's vehicle. So I took that video and sent it back to them, telling them, hey, this is not me. And still, they did not dispute the charges because it was not me. He disputed the charges because his boss told him to do so. That is what he sent in the email.
Okay, thank you.
Commissioner Douglas.
Yeah, I just want to be clear about this video situation, right? So if I'm correct, right, that in the video, right, we have some kind of Subaru, like gray, somewhere between gray and darkish black, right? Darkish gray, correct? Yeah. And we have a black man, correct?
A black man, yeah.
White woman, correct? Okay. And you're a black man and your wife is a white woman and you have a gray Subaru.
Yes.
Okay. But you're saying that the people in the video are not you and your wife?
No, they're not.
Okay. All right, thank you.
Any other commissioner questions for Mr. Obi? Seeing none, we will return to Attorney Ware. You have 5 minutes and 31 seconds if you have anything else you'd like to add.
Thank you. No, I don't, absent any questions from the commissioners.
Any commissioner questions for Attorney Ware?
Yeah, is this the only incident that is being alleged to be discriminatory? The dumping of the trash?
I mean, this is the only one I could prove.
Commissioner.
I have an issue with my air conditioning.
One minute, please.
Okay.
Commissioner David, was that a question for complainant or for
Attorney.
Attorney Ware? Okay. I'm sorry, Mr. Obi, that's a question for Attorney Ware.
Oh, okay. I'm sorry.
Yeah.
Sorry.
And so to answer the commissioner's question, it's my read at least of the complaint and also the back and forth at the Issues and Resolutions Conference that the incident that makes up the particular charge is this one singular incident. There was some back and forth at the Issues and Resolutions Conference regarding what has come up today, this issue regarding, I think, a garbage disposal and an air conditioner, but my understanding, at least based on the case as it's been litigated thus far, is this is the one allegation with respect to housing discrimination that's presently before the commission.
Thank you.
Commissioner Bryan?
Thank you. Could you answer what my question before? Do you dispute the fact that the complainant saw the video that was of a white woman, black man, and a Subaru. Are you saying that, are you agreeing or disagreeing that he looked at that video and said, that man is not me?
That is my understanding, is that he saw the video and indicated it's not him.
Okay.
Thank you. Any other commissioner questions for Attorney Ware? Okay. Attorney Clucci, you've got about half a minute left if there's anything else you'd like to add.
No, I think I'm all set. Thank you.
Commissioner questions for Attorney Clucci? Okay. Seeing none, we will turn to Investigator Morse, who was assigned to this case.
Hello, my name is Angela Morse. I'm the investigator that was assigned to this case. Just a couple things I wanted to note. So any incidents regarding a clogged sink or an air conditioner were not mentioned at all in the October 31st complaint that was filed with our office. Those are some tangential discussions, and there was no allegation that those instances were in any way connected to discrimination violative of the MHRA. I did find that printout from the company's database to be helpful. As was noted, that is the only vehicle on that one-page sheet that is listed as a Subaru that is dark gray black. This is a printout that I had requested. So, that's one of the reasons that this was supplied and why it was supplied when it is because I requested it at the Issues and Resolution Conference. I think that's all I wanted to point out, but I'm certainly willing to answer any questions.
Commissioner questions? Yeah, Commissioner David?
Well, my question is for Barbara, I guess. Well, Angela applies in the last paragraph, doesn't imply. She says that the legal standard is that the behavior would have to create a housing environment that a reasonable person would find hostile and abusive. Is that the correct legal standard, Barbara?
It was analyzed as a hostile environment claim.
Yes, and I would say, definitely applying the boilerplate language in the legal standard. We don't end up with an instance of illegal discrimination based on a protected class.
It would have turned out the same if it had been a terms and conditions analysis as well. I think.
Yeah, no, I was the hostile and abusive what I was focusing on.
Any other commissioner questions for the investigator? Okay, seeing
Can I ask
none.
a question?
No, we're done hearing from the parties and the investigators. The investigator, at this time, we are looking for a motion. There is one proposed finding.
Okay. Hold this out. I would, now I have,
Right here.
got it here. I would move that we adopt the finding that there are no reasonable grounds to believe that Bellport Management and/or CR Ventures LLC discriminated against Prosper OV based on race and/or color, and the complaint should be dismissed in accordance with 5 MRS 46122.
Second.
Moved and seconded. Any discussion?
Yeah, so I just want to put on the record that I understand where a complainant is coming from with this. But I think that the facts are really problematic. I mean, either these folks did not know of his race, right? In which case they had a Subaru listed in their database that was, yes, there may be other Subarus, but there is a Subaru there. Or they were aware of his race and his wife's race, in which case they have a video which shows a Subaru that's similar to their car. And a man that, at least is the same race as the complainant, and a woman that's the same race as complainant's wife. So I don't think that based on this isolated incident, we can find that there's racial profiling here. So I'll be voting yes.
Any further discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you'll vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay, so the findings are no reasonable grounds. The commission appreciates everyone's participation, and we will send a letter to the parties confirming the next steps.
Thank you.
A motion to go into executive
I'm
session.
making it. I'm making it.
Amazing. All right.
Pursuant
My
to
kid hates it when I tell him to do something that he's already about to do. I apologize, I take it back.
Pursuant to one MHRC section 405(6)(e), I move we go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission. It's the motion.
Okay, any discussion? Seeing none, if you are in agreement, you will vote yes. Commissioner
Yes.
David? Commissioner Ryan?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders? Yes. All right. You don't have to make a breakout room, you can just turn the camera off. And
Maybe I can.
mute Mike Barbara. Okay.
She asked how we're not done with this, but I don't know what this is.
All right, so I need a motion to come out of executive session, first of all.
So
Great. Any discussion? If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Bryan?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay. Then I need a motion not to litigate E230469 Leffler versus Eastern Events Incorporated. Okay,
Second.
any discussion? Seeing none, if you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Bryan?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay. I need a motion to authorize settlement in H210364.
So moved.
And to allow me to sign.
And to allow Barbara to sign. So, great.
Second.
Okay, if you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner Bryan?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
Okay, and a motion to authorize our participation in the lawsuit against HUD that we discussed.
So moved.
Second.
Commissioner David?
Yes.
Commissioner Bryan?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
All right, well done, y'all. Everybody go get some coffee.
We stand adjourned.